You. For our first afternoon panel, we have a very exciting topic. So we're going to speak about arbitration of banking and finance disputes. So we're talking money, money, money. And the panel will be moderated by Kenneth Miriti, who is the chairman of the ICC Kenya Commission on Banking and Finance. And I will let him briefly introduce his panel and can begin.
Thank you so much, Wanjiko. Good afternoon, everybody. Welcome to today's first afternoon session, arbitration of banking and finance disputes. We'll be talking about money, so I believe everyone has a bank account. This should be interesting. The panel I'll introduce starting from left to right. On my left, far left is James Kihara, Chartered Arbitrator. James is a partner at Kihara and Wayne Associates Advocates. He's a former chair of CIAB Kenya. He's a chair of the PPP Petition Committee of Kenya, and he's also a director at NCIA. Welcome, James. On my immediate left is Juno Pio. Juno Pio is the head of legal, litigation, and corporate functions at Stanbic Kenya Limited. Welcome, June. On my immediate right is Alan Gishui, Chartered Arbitrator, Senior Counsel. He's a senior partner of Wamai and Allen Advocates. And Alan is also the former president of the Law Society of Kenya. Welcome, Alan. On my far right, last but not least, is Deborah Ajwang. Deborah is the head of litigation and the company secretary of Jubilee Alliance General Insurance, Kenya Limited. Welcome, Deborah. To start us off, I'll begin with the first question for today. Alan, there are categories of financial disputes where issues of arbitrability may arise. Are there any categories that you think would fit in this area?
Thank you, Ken. Well, in my experience, most financial institutions, first of all, would not have an arbitration clause with their customer, for the simple reason that the general trend is that if you have an arbitration clause that a customer can use, he will effectively use it to frustrate the statutory power of sale. And that, in essence, defeats the whole purpose. Oh, it's not working? But you can hear me now. Hello? Yeah, I thought it was loud enough. I always, my wife always says I shout, but I said I talk loudly. So, generally, I haven't come across a situation except in one instance where a regional bank had an ICC clause for arbitration with its customer. And when the dispute arose, it went all the way to Paris. The bank had to pay about the deposit of $89,000. The customer was unable to raise anything close to that, and the arbitration collapsed. So in Kenya, the arbitrations that banks would engage in, and I even asked Kenya bankers, are you aware of any such move for arbitration? The customer said, no, we don't have that. But it will be basically between professionals, for example. You have a dispute clause with any professional on your panel. Could be a valuer, could be a lawyer, so that those disputes are resolved in that sphere. Maybe June can confirm that, and we just had that conversation. When it comes to, I think it was financial projects or something, that you can have those major arbitration clauses, but those are the only spheres I can think of. And also bear in mind, the bank's intention in realization of its debt is to quickly fast-track recovery. You can imagine, for example, if you had an arbitration clause and you want to exercise your statutory power of sale, and the borrower quickly goes and says, stop the proceedings, we have an arbitration clause, let's go to arbitration. And the courts will always say, oh, hold on, because it's an arbitration clause, we'll stay the proceedings, you go to arbitration. The next problem that arises is the fees for the arbitrator. And in my experience, there are very many instances where one party fails to raise the fees and frustrates the process, thus stagnates the process. Then what happens? It becomes expensive and becomes counterproductive. So it's really only in professional disputes between the bank and its providers that arbitration works. I was involved in one arbitration where a valuer had negligently carried out a valuation report. We proceeded, and in 2 months, we concluded the entire process. So that is a plus for the arbitration, because the entire arbitration was conducted in 1 day, full hearing. Now we're at the stage where the lawyer has been sacked and the award is being set aside. But bottom line is, it works where professionals are engaged, and also it gives you that confidence of privacy. And that's why I would encourage the arbitration clause, but never with the bank customer, because that will be counterproductive.
Thank you. Assuming now there are no issues with arbitrability, what are the key issues to consider when drafting an arbitration clause, and how can the same be tailored for financial disputes? James?
Thank you, Ken. Thank you, Ken. A good number of arbitration clauses that I have seen have been copy-pasted, and sometimes they have errors. You come across the same clause with the same errors that somebody has inserted into a contract. Now, this normally creates a very big problem, because you realize that if there is a problem with the drafting of that clause, that matter even takes a longer time, because sometimes you have to go back to court and try to get that interpreted. Sometimes there are contradictions within that particular clause. But there are certain key elements that you need to bear in mind when drafting the clause. Now, as Alan was saying here, dealing with the individual customers, you need to now contrast that with probably larger corporations where the amount is sometimes much higher. Now, what I'm saying is that when you draft that arbitration clause, you need to consider what is the quantum involved. I'm sure some of you have seen arbitration clauses where there is a tribunal, there is a tribunal of 3 arbitrators, but the quantum in dispute is 2 million or 3 million. Now, how do you go about that? Because if you're going to have 3 arbitrators for a claim of 2 million shillings, probably these arbitrators will consume, in terms of fees, that 2 million may be consumed by the arbitrators' fees, depending on how long, again, that dispute takes. So you need to know, are you going to have 1 arbitrator, or are you going to have a panel of 3? Something else that you need to check is in that particular clause. Now, coming to when we talk about financial services, you may want to put the qualifications of the arbitrator in that arbitration clause, so that we don't have any Tom, Dick, and Harry who is being appointed and ends up having challenges in hearing that a matter of financial nature. So even if you're going to, for example, include, if there will be if it's going to be an institutional arbitration where you have an institution like Chartered or NCIA appointing an arbitrator, you may want to insert the qualifications and sometimes also the experience of that person, because experience within that sector. So even if it is, for example, you would want a lawyer to handle the matter, has that lawyer got a background in financial services, so that when she or he sits as an arbitrator, they don't struggle with the terminologies and the procedures. The other thing I think you need to consider is the procedural rules. But these, again, would be easier to apply procedural rules of an institution other than an ad hoc arbitration. Ad hoc is where the two parties just agree on an arbitration and agree probably who is going to be the arbitrator, but what is the procedure to be followed. It is easier to use institutional rules, which are already there. All the institutions have got their own rules. Venue is very critical because, again, where is the arbitration going to be conducted? You'll need to look at, you need to decide which venue you want. Sometimes you find the disputants are coming from different entities. Maybe the bank is here and there's a corporation in Dubai. Where will you want the venue to be? And alongside the venue, you also want to consider the seat. That is the law that is going to be applied. Because you may have, again, the disputants coming from different jurisdictions. And lastly, maybe the language. When you have an international arbitration, you may want to consider the language, bearing in mind that the disputants may be coming from different jurisdictions where they're having different languages. But it is always easier. It is always easier. This is now my conclusion. It is always easier to fall back to the arbitration clauses that have been adopted by various institutions, ICC, LCIA. Locally here, if you go to Chartered Institute of Arbitrators or NCIA, they have already come up with their model draft clauses, which you can pick from there. Thank you.
Thank you, James.
May I add?
Yes, you
may
may
add
do,
to
please.
that. It's a very important thing that you raise about giving some thought to the wording of the clauses as you draft them, because what you tend to find is that when people are in the mode of drafting and agreeing, you're in a kumbaya moment. You don't imagine that there'll actually be a dispute in your future and that you'll actually need to rely on these clauses. So we do find a lot of copy pasting. And one of the examples you gave is about selection of the arbitrator. Sometimes you find some of these clauses are drafted in such a manner that the two conflicting parties need to agree on who is going to be appointed the arbitrator. And very antagonistic discussions can completely be derailed by one party completely refusing to appoint an arbitrator for years, months on end, just because we do not actually have a provision in our contracts that ensure that decisions can be made as and when they are needed. And what you find is people then sometimes, especially if the party is the one that's on the wrong, they try to frustrate the opportunity to actually resolve the matter, hoping that they will frustrate the other party. So you have to be very careful when you're drafting this documentation and always put yourself in the mind of, if I had a conflict tomorrow, can I actually realistically and practically rely on the provisions that I'm putting in this document today? Thanks.
Thank you for that, June. The arbitration clause is very important in terms of, like you've spoken, not to do copy-paste in order to prevent the arbitration clause being a dispute separate from the initial dispute that financial institution had with its client. There's the issue of ADR in resolving non-performing loans in the banking industry, realization of security, and debt collection. Jane, how can ADR assist in that area, June?
Thanks. I think Alan already threw a spanner in the works by implying that that ADR has no space in the financial space other than, arbitration, other than third-party contracting. But I'd hazard to add that it really depends on the nature of the lending. So we traditionally think of lending as our, a borrower who's taking a facility for a home loan, a mortgage, a VAF. But then banks have branched out way beyond that traditional space. Banks are now partnering with fintechs to come up with products, solutions, the mshwaris that we hear around in this market. There is a underlying contract that governs that kind of project. Banks are also involved in syndicated facilities where you'll have a group of banks financing, let's say, a power project or road building. And those are the kind of projects where you have to take a step back. Traditionally, banks are not in the business of recovering people's assets. They don't lend so that they can recover, and they do not take security so that they do not lend against security. they lend against the borrower's ability to pay. Security is literally just supposed to be a collateral and supposed to be plan Z. So therefore, when you think about it in that way, you want to have a situation where whenever there's a dispute in respect to repayment of the facility, what are you trying to achieve? Do I really want to be repaid and then we completely walk away from a power project, for example? And any bank out here will tell you no. Perhaps then if it comes to road projects, the banks will tell you the best case scenario is we need to ensure that we complete this project, and therefore in those kinds of transactions, you definitely want to have a situation, a provision in your documents that allows you to bring the parties to the table. And it really, the key ingredients that you need to consider is whenever there is a dispute, what exactly am I going to lose? And it really boils down to reputation. So as a financial entity, involved, because we all post in the dailies, so-and-so is financing this project, we all want to be affiliated. The last thing you want is egg on your face because that project blew up. Usually it's either a multinational project or a national project, the government is involved. So all the players in such instances are definitely want a win-win situation, and that's where arbitration comes in. The other one that I would mention is what Alan had alluded to earlier with respect to third parties contracting. Now, arbitration is handy here because you then need the expertise of the arbitrator, someone who understands whether it's technology. I think technology is now becoming a big one, even within the banking space, because a lot of banks are moving away from your traditional brick and mortar banking, which is you walk into a branch and you withdraw your money. Everyone here, I'm sure, has, or if your bank has already rolled out their mobile banking application. If you're sued, or if you're defrauded through that mobile banking application, who are you suing? Is it the bank? Is it the developer of that application? And if it is the developer of that application, what is the bank's recourse? Because the bank is going to sue, the bank is going to face, the bank is the face of the application. So the customer will sue the bank, but the bank needs to ensure that they have an arrangement with the provider, the developer, the fintechs in this world, to ensure that whenever there's a dispute, they don't just pull the plug. The last thing I want is that, oh, because my customers are complaining about fraud, my developer then comes and says it's not available anymore, and suddenly I'm not able to offer my customers their mobile banking facilities. So I definitely need to have a situation in my contracts where we are forced around a table to come up with a solution. Thank you.
Okay.
Yes, James.
Yeah, just allow me to just mention something here about some statistics that may be of interest to Joy and Alan. This is a survey that was done in 2013 by Queen Mary's International Arbitration. That's what they call it, arbitration survey. And litigation at that time ranked as at 82% compared with in financial services. And later, when they did the survey in 2018, the largest cases they had, number of cases they had was 56% were from the banking and financial sector. That means that arbitration in the financial sector is on the rise. I just wanted to mention that because it's, I think, critical to our discussion.
Yes. It is very critical because, as you're aware, this is a new area for the banking sector, banking finance, where arbitration is more or less can we call it an alien concept, the default mode. And like your statistics are showing, I think that's for the UK.
Yes, this is for the UK, but
yes,
also in LCIA, the same thing happened. It's gone up, and litigation has gone.
Yeah, okay. So I hope in Kenya we'll get to a stage perhaps where half the cases are going to litigation and perhaps the other half are going to the ADR process. Having spoken about the courts being the default mode kind of in Kenya, it brings the issue of appeals in arbitration. And this covers all sectors of the economy. I would like Debbie to discuss appeals in court of an arbitration award and instances where that can be done.
Can you hear me? So I'll speak, I think I need to issue a disclaimer as I speak about this in this room, seeing as I'm sitting next to some very serious fellows in arbitration. I'm not a practicing arbitrator. However, I am a user and a champion of the arbitration process. Having said that, I'd like to say that with regards to appeals, what does the law say about appeals? So in the Kenyan context, there's a right to appeal to the High Court, and on specific instances, yeah? And then beyond that, there's the question that has been, there's been a controversy about appeals to the Court of Appeal. So the Arbitration Act does allow for appeals to the High Court. And then the question then becomes, okay, if I can appeal to the High Court, then can I proceed beyond that? And we've had two different, at the Court of Appeal level, we've had two different schools of thought, where you had decisions where some of them said, no, the Court of Appeal does not have jurisdiction, and others say, no, the Court of Appeal has jurisdiction. I'll just refer you, you can look at these two cases. There's a case, Nutu versus Airtel, and then Kenya Shell Limited versus Corbill. Now that was at the Court of Appeal level, but beyond that, one of these cases, now Nutu, went to the Supreme Court, and the Supreme Court is the one that settled this matter, and specifically said that, yes, you can, the courts do have residual jurisdiction over arbitral matters, but in very specific instances. So going back to what is the hallmark of arbitration? The hallmark of arbitration is, one, finality, and two, limitation of court intervention. And that is why you can see, for instance, some of the statistics Kihara is sharing, where we see that we are having a flip. So litigation is going lower, it's going higher. But why are people actually, you then ask yourself, why are people going for arbitration? What's the hallmark of this process? It's finality. I don't want a situation as a financial institution where I am in court for years on end on a particular transaction. So the finality of it. And then number two, I don't want a situation where I get into a dispute, I go to arbitration because my contract provided for arbitration, and then post that award, somebody runs to court to challenge it. So it will just take us back to what we are avoiding, which is the litigation process, which can actually be endless. So to answer the question, yes, it has been settled that there is a right to appeal up to the highest level of court, in this instance, Supreme Court of Kenya, but in very limited circumstances. So I'm going to just speak very quickly about what are those limited circumstances. So, and very broadly, because I don't want to turn this in. Lawyers, when we speak in arbitration rooms, lawyers are not, we are the enemies. Because as you heard earlier, we are the ones who've come and complicated the arbitration process. So I'll try to keep this very simple, So what are the situations? There's a caution not to delve into the merits of the award, so that you won't have an award that has been granted by an arbitral tribunal or arbitrator, and then now we are going into the merits of that specific award. So that is avoided. Secondly, if you have a situation where there was unfairness or misconduct in the process, to protect the integrity of the process. Now, some of the situations you will have is, appointment of the arbitrator. You'll have a situation where the arbitrator actually maybe withdraws. Some of these cannot be challenged. If the High Court makes a decision in respect to an appointment of the arbitrator or an arbitrator who has actually withdrawn, then you cannot go to the Court of Appeal, to the next level, the Court of Appeal, on that particular matter. So why is this important? This is important, as I said, because you don't want to be in, a continuous, endless process. And, financial institutions, we speak money, and as June said, ours is the bottom line, and that's the reality. So as that clock ticks and, Alan's fees keeps escalating, then I'm just, my mind is just ringing the money. So I want to go to the arbitral process, and I want to conclude it there for the most part. But yes, we are alive now to the fact that there is a right to appeal, but it's limited because we want to maintain that hallmark of the arbitral process.
Okay, thank you so much for that, Debbie. Anything to add on that, Alan, before we go into the mediation?
You know, the statistics in London cannot apply in Kenya. You see, the biggest problem we have in Kenya is that when you have a complaint against an arbitrator, who do you turn to? London has a proper mechanism of discipline and a proper code of ethics. The biggest problem we have is if you have a complaint against an arbitrator here who's gone rogue, and you go to the High Court, the High Court will probably say, no, I don't find it justifiable grounds. If you lodge your complaint in London, it'll take you years. Nothing happens. So that's where, in fact, the general trend, I'll tell you now, even among some institutions in government, they've actually said after being hit with huge awards, we're removing arbitration. Why? Because we don't have proper standards of control amongst ourselves. And that is why I am still of the view that when it comes to ordinary debt collection matters, arbitration should never be. Because remember when you go to court to seek an injunction, and one of the criteria is the matter disputed or not? Even when you have an arbitration clause, remember this, the Court of Appeal has also held in Kenya. If you've admitted that and you have an arbitration clause there, it is not a matter to go to arbitration because there's no dispute, isn't it? Arbitration is about disputes. So if you borrowed money and you want to stop the sale of your property, unless you have a very valid reason, it's not something to be arbitrable. So even the issue of the limited rights of appeal, we agree there has to be finality. But what about if you're doomed if you get a rogue arbitrator? What do? You go to the High Court, you're told, sorry, you had your cake, you ate it, live with it. So it's a very dicey situation that I, as a chartered arbitrator, have come across instances where I despair as to certain awards that have been rendered that are totally irreconcilable with law and justice. And when you try to set aside, you fail. So to the point that now we ask each other, who do we refer this to? Is that a good arbitrator or not? It's come to that. That's the reality. And the only way we can make arbitration work here is for us to come up, and I've always been the firm belief that we must have a regional or Kenyanized code of ethics with a disciplinary body that can look into it. So what is the solution? Right now, the closest we have is NCIA. You go to NCIA, the regulatory framework limits you to determining the dispute within a certain time frame. They can also moderate your fees if you overcharge. So if I'm asked honestly and frankly, I'll say put the NCIA clause. That's what my clients ask me. If I go to chartered and I'm a chartered member, the problem we have is, what control do you have if you get an arbitrator? Who do you complain to? And when clients come to me, I say, gosh, I don't know what to do. You just have a nerve-wracking moment as to how to assist. But don't get me wrong, majority of us are excellent arbitrators, and we mean well. But in every society, we'll always have a few rogue elements amongst ourselves who give us a bad name.
Thank you so much for that, Alan. Just to mention that as arbitrators, one of the worst things that can happen is to have your award set aside by court. Reputational risk. There is an alternative to the litigation arbitration, and that is to mediate. Mediation of financial disputes is also another area that has been tried in this country before. And I would like Alan to discuss mediation of financial disputes and its benefits.
Thank you. Now there we're in agreement. I believe in mediation for the simple reason that I was in the committee that drafted Kenya's first court-mandated mediation rules in 2004-2005. But on a serious note, when you look at mediation really, It's really an amicable, time-sensitive, and tried and tested way. The two aspects of mediation here that can be applied is if the bank or financial institution goes to court, the matter is screened, and then you go for court-mandated mediation, which is time-sensitive within 60 days, with liberty to extend. The problem I see is not just lawyers, but even clients don't understand that mediation is not supposed to be so adversarial. It's supposed to be a very loose manner of trying to amicably resolve the dispute, and then we bring the litigation adversary aspect in it. Now we have the latest 2022 mediation rules that cater for both court-mandated and private mediation agreements. So the banks can actually import the issue of private mediation agreements, where you can pick a qualified mediator who can resolve the dispute within 3 months. It works. There are quite a number of instances where we have successfully seen mediation work. And in many instances, it saves time, it saves costs, and it will really be the practical way to go. And I'm happy to know that it's really picking up. There's a lot of training going on of mediators. We have many qualified mediators in place. And that is one aspect that should really be considered as a go-to place for most of these disputes. Of course, when you've got the recalcitrant borrower, and they're always there, they'll try all means possible. I was once involved in a mediation, and the person who was difficult is not me as a lawyer, my opponent was a lawyer, but my own clients. Afterwards, the client came on and told me, "We did like the way you're talking to that lawyer in such a charming manner. What the heck were you discussing? And we're not very happy with what you're doing." So I told him, you know what? I'm a professional. He's a fellow professional. We work together. If you want me to be in a combative situation, then I'm not your kind of lawyer. So I told him, adios, take a hike. Because for me, it's integrity that's more important than just money in the pocket. At the end of the day, what happened? They failed to mediate. They went to the arbitration. They lost. All simply because they had a chance to mediate and they could have actually worked out something reasonably conducive to them. And that's why we need to learn about mediation. And just to wind up on that, the other day I got a demand to go to mediation from a lawyer. And what did the lawyer do? He proposed to have drafted proceedings and titled them mediation proceedings. So we wondered, which court or institution is this called mediation proceedings? And instead of, with mediation, it's a simple case statement, isn't it? This guy gives us case law in it, relieves of asking millions of shillings. It's an ordinary plaint. So ignorance of the law also besets most of us in not reading, and that's the biggest problem that hinders mediation. Of course, when we have trainings, the people who should be in that training are not there, and they're the ones who mislead their clients. And actually, the simplicity and beauty of mediation, which in my view is really a fantastic way to resolve disputes.
Thank you, Alan. You've brought an important aspect, client knowledge. So I think there's a lot the audience is getting from there. June, you have something to add?
A lot to add, but I'll keep it brief. I was nodding emphatically because in a way when you think about it, the mediation commences even before the bank commences the process of recovery. It takes 90 days of the bank calling you probably every other week. We become your best friend and your mpango wa kando because we are calling you at 6 p.m. asking you to repay your facility before the banks even commence legal process of recovery. So the bank is always inviting borrowers in distress to come to the table. Unfortunately, the culture, I think, in the country and the background, the history is that people just believe that banks are draconian institutions and just want to take everything and, leave you completely penniless. And so you find borrowers will run away, they'll ignore calls, and then it's only an auctioneer who will finally find them and the asset that they've hidden. We've had trucks buried in, Deborah, in your former life, these things. You find your assets are buried under a hole somewhere or in a cave or outside the country just because they are trying not to pay you. So there are three types of borrowers. Borrowers who from the day one, they know they will repay the facilities and they religiously pay it, no problem. Borrowers who from day one have absolutely no intention of repaying your facility. They draw down and then they switch off their phone so that and when you send them M-Pesa, they said, don't send me M-Pesa to this number because I have a facility. Then you have the third type of borrower, a borrower who had the intention all along to repay, but for whatever reason has come across difficulties and is unable to pay. That's a type of borrower where mediation works perfectly. I think the change that perhaps we need to do is educate and raise awareness, because there's a lot of mistrust. If this is, they look at financial organizations as the party with the power, and therefore they don't trust what the banks are telling them, and therefore involving an independent mediator in the room would probably move that conversation along. Thanks.
James, you like to add?
Yeah, just to add. There was a time there was a very big push by Kenya Bankers Association to include mediation, because there were a lot of disputes that were in court, banking disputes in the financial sector. I don't know why that push, I don't know what happened, but I remember they had set up in partnership with the Strathmore Dispute Center. I remember participating in their meetings. The intention was that the disputes from banks were to go to Strathmore Dispute Resolution Center for mediation, not arbitration, for mediation. And I don't know what happened to that, and that was...
it's actually being revived.
It's been revived.
Yeah, we're working on reviving that, okay. Yeah.
Debbie, you can chip in as a user.
Yes, two things. I think we need to appreciate that there's also lack of information, but also what is, like she says, the personalities, the character of the borrowers, and that's very important. And my challenge with mediation is, and then I completely support what Alan says, that we need to, apply it, and the court annex mediation is there. But you find that borrowers actually feel like this thing is not useful because they say it's not binding. So what are we doing here? They want to go to court so that I have my court order that I can enforce. That is still there, and that's something that we need to address in this conversation, Yeah, and then as you answer that, the second thing you asked about the mediation, and that's part of the reason why that process you're talking about did not kick off, Kihara, with Strathmore. It's a brilliant idea, but at some point, we felt like, is this textbook? So we need to move from the textbook to the reality. You see, with the court annexed mediation, the way it started and the way it was launched, okay, yes, there was sensitization with the Kenya Bankers Association, but then you also find that it's like you're sort of forced. You know what I mean? You start the process, you're in court, and then you hear that this matter has been sent to mediation. So the parties really don't have a choice. They find themselves in that situation. If you were to ask some of them, they would say, I really don't want, I really don't want into mediation. But this has now been tied into the litigation process, and so we've been forced to actually take it up and use it in our process. And for sure, I agree, it has worked. I've had cases which have been referred to court annexed mediation, and within 6 months, they were done. And very murky cases, But still, at the back of our minds, we have to remember that there's the character of the borrower, and that's very important.
Finally, Alan.
Just one point on that issue. Once you have a private mediation agreement and you reach a settlement, the law now allows you under Section 59 of the CPA, Civil Procedure Act, and also the rules, just to go to court and have it enforced as a decree. So that's the beauty of it now. So in 2 months or 3 months, you have your mediation agreement, you can go file the application in court, it's enforced as a decree, and the customer and borrower will be very happy to even post it and frame it in the house.
Nice to hear that, because when it comes to money, it's a very emotive issue, and you're asking people to mediate when temperatures are already very high. The tradition here is, let's go to court. That's the default mode, both the bankers and the customers. So I think we've got a lot to take on that. We'll move again back to the arbitration fields, part of ADR. We've discussed arbitration. And James, what can be said about the choice of arbitrators in handling disputes in banking and other financial services?
Thank you, Ken. And To answer you, I'd like to probably build on what Alan had said, was talking about earlier, about the quality of the awards. And some of the awards, you read them and you're in shock, like, how was this award drafted? One of the most important things, I believe, when appointing an arbitrator is you need to know what are his qualifications. That's number one. The reason I say this is because you'll find there are institutions where probably they say, as we're appointing, we'll start with James, and then we end up with Deborah. But what I think is more critical is the appointing institution needs to look at the entire bundle of pleadings or the dispute to understand what kind of dispute is this, so that we know which arbitrator are we going to appoint in this dispute. Because sometimes you find somebody has been appointed, it's a complicated matter for that person, they say they can handle it, and then they start having challenges on the way. What kind of quality, what will be the quality of the award of that person? So for me, qualifications are very critical, because you can say here that this is a dispute, construction dispute, let's say construction dispute. You need to look at it and see whether it is best for a lawyer to handle it, because sometimes there are just legal interpretation issues, or is it something to do with the accountability of that construction process, so that do we need somebody who understands the construction industry very well? So you need to know that is very critical. So when you come to the financial sector, the same thing. Does this person understand financial services? Has this person ever worked in a bank or a financial institution so that they can understand the terminologies and the practice in that area? The other thing that I consider critical when you're choosing an arbitrator is you need to know the experience of the arbitrator. The fact that probably somebody is 60 years or 50 years for that matter does not mean that that person may have had a lot of experience within the arbitration sector. Because some of us, you start learning arbitration later, others they started a bit earlier. You need to see what is the experience of this person. How many arbitrations has this person conducted? What type of arbitrations has this person conducted? So there's quite a lot of research that you would need to do before you identify an arbitrator. Now, something else that you need to consider is where there is a tripartite arbitration, where you have a chair and 2 members, you may want to consider diversity, okay? You may want to consider diversity in terms of the expertise of the 3 arbitrators that you're going to appoint. But locally here, I think one of the easiest ways of seeking information about the arbitrators is, for example, if you go to Kenya law, there are a lot of case laws there. You find case laws and then you'll understand who is this person you're appointing as an arbitrator, because there are cases that have gone to court and judges have actually gone through pleadings and made certain comments about some arbitrators. You may want to look at that. You can also talk to senior members of the profession to understand about the person that you're appointing. But it is absolutely critical, because remember, as Deborah said, there is very little you can take to the court afterwards. Once your award has been given, it's done and dusted. Yeah.
Thank you so much, James. To close, we shall talk about the issue of costs. As you're aware, there are benefits of arbitration over litigation, including the choice and flexibility. It's confidential. There's expertise, which James has just talked about, having an arbitrator with expertise or knowledge in that field. And then there's the finality, which Debbie talked about. But the big, and this is debatable, the issue of cost and speed. And there are concerns about the overall cost of arbitration. Are these concerns valid, and how can they be addressed? Debbie?
Thank you, Ken. On the issue of costs, I think for me, looking at it from speaking as a user in the financial services, what has happened is previously, of course, the go-to dispute resolution mechanism was litigation. Then we realized that this is not working, so an alternative came. That's why it's called alternative dispute resolution, which is arbitration. But then we realized that this alternative was actually becoming just as expensive. Why did this happen? Because fortunately or unfortunately, practitioners who are lawyers, arbitration practitioners who are lawyers, complicated the process and made it long and expensive, because of, and I'm speaking as one, we came with our mentality, what we know from the litigation adversarial process. So what you find with financial institutions is that, and in addition to, aside from what Alan said, that it doesn't really work well where you have specific, where you have debt, the debt collection process. But with the other processes, we now are looking at it from the aspect of it's taking long, just as long as litigation. It's very expensive because we are billing per hour. So what would I say about that? I think looking at it as an alternative dispute resolution process, it's the way that arbitration practitioners present it to the financial institutions in terms of the value. So it's the value proposition that needs to be sold. In this way, is there a way that you're going to cap your fees? Is that possible? Have that conversation from the onset. Is it possible to actually agree on fees up front so that the financial institution is not surprised, by the fees you negotiate, if, within, of course, certain framework. Second to that is speed, speed and efficiency. There are certain processes that you see. I've gone through an arbitration, sitting on the financial services side, where we spent so much time doing back and forth, and it felt like I was back in court, which is what I was avoiding in the first instance. So if arbitration practitioners can actually shorten that process, and I was glad I attended yesterday's session, where some of the senior arbitrators were actually sharing how you can reduce those sessions and those exchange of documents. You can actually agree on the issues, exchange the documents, so that we don't have you billing, as Noella said, 702 hours for perusing documents. Because if you bring that to me in the financial institution, I have to convince my management or my board on what you are doing for 702 hours, and that's going to be a tall order for me. So it's bottom line is about the value proposition, and I think the uptake of this, as we've seen, is positive. It's just about how you package it. The value proposition, time is money when it comes to financial services. So we look at, that is the bottom line for us.
June, you can add something on the issue of costs in arbitration.
Indeed. So in addition to what Debbie's alluded to in terms of managing the cost, it's also, perhaps we could also come up with a structure where commitment to the process is assured from the beginning. And I'm speaking to instances where a matter is taken in for arbitration, the parties have selected the arbitrator, fees have been agreed up front, the arbitration process is concluded, and the parties are then invited to settle their fees. And then what tends to happen is perhaps the party that feels that this is going against them decides that they're not going to pay their fees. So you end up in a situation where you're holding one of the parties ransom because the arbitrator is not about to release the award if they haven't been paid. And this is an issue that you find is now becoming a challenge, especially if the fees were not capped up front, and therefore it's quite an insurmountable amount perhaps for one of the parties. And then also, again, speaking to what we were mentioning earlier about the nature of the parties. So if it's a corporate or an organization for which the reputational issue arising from the dispute is of such magnitude that they are willing to pay, then you probably will not have the issues in respect to fees. But if it is someone who doesn't care about their reputation and can walk away whether or not the ruling is finally provided, the arbitrator is left having invested all this time. The other party is also left without a conclusion, and the matter can just lay in limbo until one of them decides to pay up in full and hope to recover from their award. Thanks.
James, you'd like to add on that?
Yes, I wanted to say something about what Deborah has said about time vis-a-vis the costs. Okay. Now, if you'll note that in quite a number of arbitrations nowadays, because lawyers, we are litigious, we like litigation, and you find that you see that many lawyers, there's a tendency nowadays, many lawyers representing parties in arbitration to pick anything small and go to the high court, like on jurisdiction. There's so many applications on jurisdiction. Now, the problem with that is that you find that an arbitration that could take probably 1 year takes 2 years or 3 years, because the High Court takes some 1 year or 1.5 years just to hear that simple application. And essentially that defeats the purpose of arbitration. So even, Deborah, where you have capped the fees of, for example, the party, I mean, for your advocate who is representing you in that arbitration, this challenge on jurisdiction is like a totally different case, and you may get another fee note. What I would propose is the way we have capped the time, within which the High Court hears procurement disputes. It should be the same thing with arbitration disputes, because we want to hear the dispute within the shortest time possible. But once there is a challenge and there is all this exchange of pleadings, we should have something like 45 days. I think the procurement is 45 days or 60 days, and the judge cannot go beyond that date without rendering his decision or his ruling.
Just to add on that, James, to inform that because of the concerns on costs and speed, there is now a process called the expedited arbitration that's available at the Chartered Institute of Arbitrators. And there's also the fast track process, where within 60 days, you should have an award on that particular matter. So that's one of the steps that have been taken to cap costs and speed up the process. I think Alan has something to add before we wind up with Debbie.
Thank you. I was actually going to mention that. In fact, in 2020, in Chartered Institute, we drafted the rules and brought about fast track, which is documents only, and that will be concluded in total from start to finish within 60 days. So that's one area that you can look at if you really want to expedite it. And also, as an arbitrator, much as I try to tell parties, look, why don't you narrow down issues? Why don't you agree on a timeline? How much are you going to spend on each witness? At the end of the day, I can't force the parties, because they'll say you've been too bossy. It is our arbitration. We want to handle it in this manner. So I have an arbitration going on now for 6 years. I'm serious. Why? Because of simple accounting. We can't get an expert to come down to really come up with a proper accounting of what to do. I had an arbitration that went up. I was not the arbitrator, but I was for the claimant. We went up to the Court of Appeal twice over the years. And eventually we got the award. It's been set aside. So the thing is, we can really frustrate each other if you so wish. But at the end of the day, as an arbitrator, I always ask, what is the issue? There's no point of putting in, I saw a claim that was 180 pages long, 400 paragraphs. And I was told, can you come here and lead? Do you know, the first thing that intimidated me was when I was told, the documents, remember Patney of those days, yeah? They're a pickup. I just declined. Where will I get the time to prepare for an arbitration? I was given 2 weeks notice to take over and look at a truckload. You think it's the Supreme Court. And then most of it could have been hot air. So at the end of it all, we are guilty of prolonging the matter. So you see the poor arbitrator having to go through all those documents and then spending, well, not 700 hours, but you will spend time because you've put in irrelevant documents, while all you have to do is narrow down the issue and work backwards. How do you support that issue? That's the way you can keep costs down.
Debbie, just to end up on that, you have something to add?
I actually just want, mine is a question, is there a space for self-representation?
Yes. I hope I'm not interceding on somebody. I did write an article on self-representation, and that's one of the biggest solutions. As a client, you're in control of the process. You need not wait for 6 years, like Alan has said. You can decide to represent yourself before an arbitrator. Banks and financial institutions are very good with documents. You can't, because arbitration is not so much about technicalities and legalese. You can go through the expedited arbitration or the fast track and represent yourself. Come with the documents. You've got your director of credit, you've got your operations manager, you've got your trade finance, whatever the dispute relates to. They can appear before the arbitrator, represent the bank, and surely I can assure you most likely that dispute will narrow down from the 400 pages to perhaps 2 pages, because that's where the problem was. So again, that's one of a new area that's coming up, self-representation. May not be very popular with the lawyers, but it is what it is for the arbitration profession, and it's a solution to some of the challenges we are facing. So I think as we wind up, if there's any comment from the panelists on any of the arbitration banking disputes, we wind up. Thank you so much then for your time. I think we've come to the end of our presentation today.
Okay. Thank you very much, Kenneth, and your very knowledgeable panel. Time always flies when you're talking about money, so. But, so I'll just call up the next panel, which will be moderated by Gordon Odwor. So we have Dr. Mwegwa, Jackie, and Wanjiro. Okay, thank you.
Okay, good afternoon. As you've heard, my name is Gordon Odwor, and I'll be moderating a panel on environmental, social, and governance in arbitration. And what we're trying to look into is how can we plug in and stay ahead of the curve as arbitrators or as arbitration practitioners. So with me in this panel, I'll introduce, I think starting from my right, is Dr. Kariuki Mwigwa, a well-known scholar and practitioner on matters of environmental law and international arbitration. I think it doesn't need much more introduction beyond that. And then to my immediate left, that will be Wanjiru Ngige, a partner at Mohammed Muigai, LLP. She specializes in dispute resolution, and she's a member of the Kenyan Bar, both the Kenyan Bar and England and Wales. And then to my far left, that would be Ms. Jacqueline Wahenya, a managing partner at JWM Law LLP. She also specializes in corporate law and dispute resolution. She's an advocate of the High Court of Kenya, a mediator, a chartered arbitrator, and a vice chairperson of the Chartered Institute of Arbitrators. Welcome. So maybe to begin with, I'll ask Dr. Kariuki Mwigwa to take us through the introduction of what do you understand by the words environmental, social, and governance in arbitration?
What I prefer to do is give you that presentation in 7 minutes. You didn't tell them you gave me 7 minutes.
Okay. I presumed we agreed on that, but yes. So he'll take 7 minutes to do that introduction. Thank you.
Good afternoon. Good afternoon. You can hear me from that side? The topic is ESG, and ESG means environmental, social, and governance. Well, it doesn't sound grammatically correct, but if you think about environmental, social, and governance issues, or tenets, then you probably can correct it. And this is something that seeks to incorporate environmental, social, and governance concerns in corporate decision-making. Increasingly, the whole world is realizing that the environment is important. The idea that the right to a clean and healthy environment is a human right. A while back, human rights used to start with civil and political rights. The right to vote this coming Monday. But surely, if you don't eat today and tomorrow, you cannot send a corpse to vote. So environment then has come up. And in the idea of doing business by corporations, especially across Africa and other regions, we ask the question, are those businesses sustainable? Are they ethical? And are they responsible? Corporate behavior. Corporate governance used to be about what people discuss across the red carpet. I think now it is what people discuss across the green carpet, or a confluence between that, the red carpet and the green carpet, where green is the environment itself. So there's the E pillar, the environmental pillar, and we talk about sustainability. Is what that company is doing sustainable? Is it? How about climate change? How are we contributing to climate change? Are we aware of climate change mitigation, adaptation, and so on? The S pillar represents socially conscious investments. What is it you're doing with the society itself? Do you respect human rights? Do you have good labor practices? Or are you running what is called a sweatshop? And those are no longer idle questions. The G pillar is concerned with good governance practices. Are you transparent? Are you accountable? And everyone will tell you that ESG now is an important corporate governance tool. You cannot ignore it. So what has it got to do with arbitration? I had someone the other day telling me that sustainable development has nothing to do with arbitration. And this is a senior person, so from where I come from, you don't answer back. And he's also a professor. So I didn't say much. But it has everything to do with arbitration. Because as companies trade, and as they deal with these matters, then they are met with climate change litigation. They are met with environmental litigation. And there are all manner of examples of environmental litigation. Cortec mining, for example, was something to do with environmental. What do you do when the company is violating environmental laws of the country? What is it you can do when a company is violating human rights? So there's an increase in those matters. And how do they enter litigation? There is what is called ESG clauses. And they are very common now. They come before, they are placed just before the arbitration clause or the dispute resolution clause. And parties will say, you pledge not to violate human rights. you pledge not to mess up, so as it were, the environment. You pledge not to run a sweatshop, so that now when you do, it is part of the contract. You can see how they are. So they're increasingly being incorporated in commercial contracts. You will see it in every other World Bank contract, contracts relating to trade, and you see it across all investment treaties. So arbitrators then are called upon to consider these ESG concerns because they relate to them. They will catch up with you, especially when you are dealing with investment disputes, anything to do with climate change litigation. So that's where arbitrators come in. So what is it then we must do as conflict resolvers, as arbitrators? We must have an understanding of the concept of ESG. ESG practitioners must understand what it is. I have put before you two papers. One is called Realizing Environmental, Social, and Governance Tenets for Sustainable Development. The other one is called Embracing Environmental, Social, Governance Principles for Sustainable Development in Kenya. So it's relevant to Kenya. And if you do not know these things as an arbitrator, don't sit there pretending you understand. Get help. If you don't know anything about how carbon is traded, get an expert. If you don't know the lingo in regards to climate change concerns, get an expert. What is it that arbitrators can do in all their arbitral awards? Ensure you're upholding human rights, environmental rights, and social license issues are covered. You should always be clear and promote good governance practices, such as transparency and accountability. And finally, I assert that arbitrators have every business promoting sustainable development. Thank you. And that's not 7 minutes, that's less. Thank you.
Thank you, Dr. And you've kept your word, exactly 7 minutes. I appreciate it. So next, maybe I would go to my immediate, the next question will be to my immediate right, Wanjiru Ngige, and I would ask the same question, but would you kindly, in addition to that, touch on the social factors of ESG?
Thank you very much, Gordon. Following on from what Dr. Muigwa has said about the environment, the S in ESG stands for social impact. What are the social impacts of your investment or of your contract? What we mean by that? We mean the people, the communities. ESG is all about profits, number one, the 3 Ps, people, and the planet. So that's an easy way of trying to remember what these ESG issues are all about. And in terms of social impact, we're looking at labor practices, we're looking at gender and diversity. In fact, on that note, I'm glad to see that we are very gender balanced panel. We're looking at things like the environment to some extent because of the places where people earn their livelihoods. If we look at something like the Lamu development, the port of Lamu that is being developed, there are all these concerns about the fisher folk, whether the environment will be destroyed to an extent where they cannot fish anymore. So those things have some overlap in them as well. The wider the scope of a business, the more you will look at these various factors. In fact, globalization is such a massive contributor to this conversation. Dr. Muigwa has talked about sweatshops. For some reason, people nowadays don't like to be associated with child labor. So, of course, you will find that when we have global suppliers in the south, like in Sri Lanka, in India, in Bangladesh, and their purchasers are in the UK, then there's a branding aspect to bad labor practices. And so now those become a feature of the contracts that are between the supplier and the purchaser. Another example, for instance, when we talk about market standards, all of you are familiar with the horticultural trade, and you all know that a consolidator in Kenya will come up with a lot of smallholder producers, put them all together, buy their produce and send it to the UK or the European Union. Any problem with pesticide residues will have the whole batch rejected. And so those issues become very important for that reason of markets as well. I think one other issue that I think is very close to home is the diversion of profits. You're all familiar with what happened with the Kakuzi issue. I think it was last year or maybe in the year 2019, where a UK shareholder in Kakuzi had to pay off about maybe $2.6 million just in Kenya alone to deal with human rights abuses. And just before that, in Malawi, they had paid another £4 million in respect of those abuses. So those issues become very alive, they become very concerning, and people will now have contracts, contractual clauses that build in those social factors. Of course, you will sell us this good at this price, you will sell us this dress at this price, but you must have paid your laborer a fair wage. You must have proper environmental standards to take care of those problems that we do not want to affect our brand. Those are some of the issues that I think arise from the social aspect of ESG. Thank you.
Thank you, Anjiru. That's well put. And the next question, I have to make a cap. I appreciate this will be probably a much more packed question for you, Ms. Jacqueline Waihenya. But probably if you will just walk us through some of the governance measures already put in place to address ESG, both at the international level and domestically in Kenya.
Thank you so much, Gordon. In fact, I was thinking I'm going to have an easy ride now that I'm the third presenter. Before I say anything about the governance aspect, I just want to probably emphasize on one word that Dr. Mwigwa mentioned, and that is congruence or confluence. And the truth of the matter is, even though we look at ESG as in the sense of pillars or separate, they are almost two sides of the same coin, or even three sides of the same coin. So we've talked about, or we've heard about, the environmental aspect, and we've also heard about some of the social issues from my fellow presenters. What governance does is to record. It records what is happening on the environmental compliance side and also the social compliance side. And when it does that, what happens is that the organization that is subject to ESG, and increasingly it is all organizations, they have to keep a record that they are complying. Because me as an investor or as the member of the organization, I want to see that I am secure. The compliance clauses will be prevalent in almost all the engagements with suppliers or even with customers down the line, or the shipping process, the transportation process, and also how the organization manages its own systems as well as procedures and policies, just to ensure that they comply. The bedrock of the instruments that require compliance, and I think where we got our the source of ESG can be traced back to the United Nations SDGs, the Sustainable Development Goals, and there are 17 goals with 169 targets and 232 indicators. And this is the beginning point for any organization. The SDGs will have the environment, the social, they'll also be the governance, because when you talk about ethics, then you're also talking about how the organization is governing itself. So each organization is part of a country, and that country is also part of the United Nations, and we have already made commitments to the globe. We want to be good global citizens. We're operating, or many of the organizations we work with or are influenced with are operating on what they are calling the global concept. Global plus local. They are global organizations, but they operate in a local context. So coming from the SDGs, very many instruments have emerged. And I'd hope that we'd be able to take a look at the presentation that I'd prepared, and there was a map of the world. And if you look at the map of the world, every single nation in the world is subject to at least one or two, mostly almost numbering to 10 instruments, that statutes, regulations that they need to comply with that have an impact, a direct impact on governance. So I will speak to governance, but please remember, when you start with SDGs, the environmental will have a big impact, the social, human rights. In fact, it's economic, social, cultural, all those things have a bearing. And we'll find that more and more tribunals are looking to enforce, recognize, because it is now a contractual obligation. So I will talk about the legal framework, and mostly just to mention, because I cannot speak about all the instruments that pertain, but so that you can also have a reference point. These are instruments that you should be looking out for as an arbitrator, and also making sure that they are being followed. Be alive to what is required, and ask yourself also, how are they measured? The companies are supposed to keep records. They need to comply. They need to, and many of them have compliance matrices that are annual. Some are monthly, some are quarterly. I'll mention some, and of course, we start with our constitution in Kenya. That's the GRUNOM. That's where we find a number of the, go to the Bill of Rights. It is complete with very many social rights that the people of Kenya have, and environmental rights as well. When we come to the governance aspect only, if you look at the Capital Markets Authority, they passed the Code of Corporate Governance Practices for Issuers of Securities to the public in 2015, and this has mandatory requirements for any listed company in Kenya. And all I can say at this point in time is that there is a need for corporate ESG disclosure. So the disclosure will relate to, are you subject to any environmental provisions? Now, if you are subject to NEMA, definitely there is something that you need to be doing. Recently, I believe they passed the Sustainable Waste Management Act. The regulations that are coming out, there will be a compliance aspect and a matrix or issues that need to be included in that matrix as well. So you need to disclose, yes, we are subject, and then indicate whether or how you are complying. And we call this comply or explain. Now, that is the general status or expectation around the world for governance matters. Comply or explain. Not many countries. One country, that is South Africa, has moved a step forward and said, you must comply and you must explain, which means you comply and indicate where you have complied. If you haven't complied, then you indicate why not, and also, if not, when are you going to comply? So we also have, and this is called the Guidance on Climate-Related Risk Management 2002, which was issued by the Central Bank of Kenya. It applies to insurers and also regulated pension schemes or entities. There's a National Action Plan on Business and Human Rights, and this domesticated the United Nations Guiding Principles on Business and Human Rights. Also from the Capital Markets Authority, we have the Stewardship Code for Institutional Investors 2017, and we have a corporate governance guideline for the water sector, which was issued by the Ministry of Water in 2018. There is a general code that is applicable to public organizations called Mwongozo. The proper title is the Code of Corporate Governance for State Corporations. Now, these are all instruments or statutes that have emerged from the past. The truth is, we are now in the post-COVID era. After the COVID pandemic and the impact that it had, there is a lot of discussion on how compliance needs to be done and what needs to happen if there is no compliance. And for governance, then that means that it is important for the governance entity, which is your organization, including individuals yourself, to make sure that you're also in compliance with the ESG policies and the regulatory framework. So I know there's going to be a panel later on that will talk about the impact, but if you also have been aware, there was the groundbreaking Shell decision by the Hague District, and this was the first time a court imposed a legal obligation on a company to reduce CO2 emissions. So if it is happening there, it is going to come and affect us very quickly. One of the biggest impacts of that case was the European Commission's, they call them the Fit for 55% legislative package, is currently under discussion. The stakeholder management, the stakeholder participation or the equivalent ended, so they're not receiving any more comments on the same. However, what is happening is that we're expecting that there shall be some EU directives, either towards the end of this year or next year, and these are going to make it mandatory for organizations who have a presence in the EU to comply with those directives. Of course, the content is coming out, we'll find out, and we will see the extent to which it affects. What I can say is the proposal is that it affects those organizations, it affects their suppliers, it affects their customers, which pretty much means if you're Amazon or Microsoft and you have a presence there, then your Kenyan organization is also going to be subject to disclosure, even in respect of their suppliers and their customers, which means that if there are ESG compliance clauses coming into place, then they will be in all the boilerplates that the organizations are going to be putting in. Therefore, just looking at the regulatory framework, there is a rich opportunity for dispute resolution, because in reality what happens, we have what we aim for, but in truth, we have sloppy reporting, we have non-compliance, and when there's non-compliance, then there's a domino effect of disputes and the loss that attaches, and somebody is going to want that loss to be at least adjudicated by a competent tribunal. I'll stop there. I don't know whether I've gone beyond my 7 minutes. If not, you can ask me another question in that area.
It's okay. Thank you so much, Jacqueline. Thank you for the effort to unpack so much within a very limited time. Indeed, it's an interesting area. So maybe if I might go back to Dr. Kariuki Mwigwa and just ask, how should arbitrators deal with ESG-related clauses? And maybe just to pack that a little bit more is, how are arbitrators, or how should arbitrators deal with ESG-related disputes in arbitration?
I think arbitrators should bear in mind that whatever it is they are deciding has something to do with the environment, whether it's pleaded or not. It may well be that it may exist as a clause just before the dispute resolution clause. And in that case, you then ask yourself, what is the import of this clause to this agreement? What will happen if I order the following? And then you ask yourself, for example, if a company is polluting the only river somewhere and ensuring really that there's no clean and healthy environment, what would your award be? So in other words, since 2016, when we passed the Sustainable Development Goals, we are under an obligation, under international law and local law, to ensure that whatever we do, we take care of sustainable development, we take care of the environment itself. If you are in the jurisdiction of Kenya, you will have Article 11, which talks about sustainable development, Article 60, Article 69, Article 70, at the back of your mind. But in a lot of the modern agreements that will be placed before you, and investment agreements, you will find it expressly stated that the company X shall not abuse human rights, shall get the social license to practice, shall observe what is called FPIC. FPIC is free, prior, informed consent. In other words, we are moving away from generations ago when there was colonialism, and it didn't matter one bit what the companies are doing. So that awareness is with us here. And whether you see it in a document or not, you must have cognizance of it, you must be aware of it, and you must be able to keep it at the back of your mind. But having said that, ESG is sounding nice, but it's resisted by companies. Why? It affects their bottom line. And we've seen companies in the West moving their operations to other areas where they can pollute. The regulation is less. The so-called sweatshops. So a company in the US will tell you, we are clean, but they are doing all their manufacturing in China or some other place. As we talk now, ESG is not that nice thing that you can go and take to the boardroom. You meet resistance, you'll be fought. So what is it we need to do? Is it more regulation? Is it something political? Is it persuasive? What is it we are going to do? Is it awareness? But we must take care of the planet. The planet is very small. It's not able to absorb all the pollution that we are putting out there. Thanks.
Allow me. The way I understand an ESG clause in a commercial contract, perhaps maybe lays out the way in which an arbitrator would approach it, such that if I am company A and I have contracted company B to supply my clothing that I want to sell in a different company, then my arbitration clause, or rather my ESG clause, would say something like, you must pay X amount, you must have particular labor standards, and you must meet minimum environmental standards to operate for me to continue contracting you to supply these clothes. And so therefore, if I am an arbitrator and I see such a clause, then I will then examine what practices are these people employing in the manufacturing of their clothes for this other person to say or to allege that there has been a contractual breach. That's how I would look at it. And then that would give you the parameters, because I think it would be very difficult, of course, except for great minds who are very in tune with the environment and the standards and everything that it requires, to say that they're going to go and save the planet all at once. That would be difficult. What you're doing is saving the planet in the context of that particular clause, in that particular agreement, I think.
Do you have something to add, Ms. Wahenya?
Okay, well, I was just going to talk about the ESG compliance clause because, Wanjiru talked about what the compliance clause is. One of the usual boilerplate ones I've come across it goes something like this. The company shall use commercially reasonable efforts to comply with applicable environmental, social, and governance laws and regulations, and shall foresee any known or expected future changes in the requirements and take all reasonable actions to ensure compliance. The company shall respond diligently to requests of information on ESG matters received from the investors. In case any ESG incident occurs, the company shall proactively inform the major investors as soon as practicable. That's one of the usual ones which I've seen, and they don't give very detailed mechanisms for how ESG should be engaged in, which presents a first challenge to an arbitrator, because now you're set on almost a fishing expedition. And in arbitration, you need your parties to be able to bring forth those issues before you. Otherwise, you cannot decide on issues they have not presented before you. So that means that, number one, we need to be extremely innovative in how we deal with some of the disputes. I'll give you an example. There's a company, and this is a personal experience. We purchased cryptocurrency mining rights. We are innovative, we are really ahead of the curve. And this company told us that they are mining in China. But then China decided that they are going to float their own digital currency, and they chased away everybody who is involved in cryptocurrency. So what the company did with our money and our interest and our dreams is to take the mining effort to Kazakhstan. We're like, where is that? It's a we are global. We are a global company. We go to Kazakhstan, and then they mine, and everything is going fine, and they're producing well, and we are feeling we're making money. And one fine morning, we are told that, oh, sorry, the mining operation in Kazakhstan has been shut down. And then the question is, why? Oh, we went to a small town in Kazakhstan, and then you understand that when we are mining cryptocurrency, it requires a lot of electricity. So the town started experiencing electricity shortages intermittently. And then as the mining project became even bigger, intermittent became regular, and at one point, the electricity just collapsed the entire power grid for one whole city. So they had to shut down the whole operation. So now, assuming you are the arbitrator, and I brought you this matter and this claim, and I said there's an ESG compliance clause. Where do you even begin? What are the rules in Kazakhstan? Where are we going to have a seat? What are we going to do? So we have been sitting there asking ourselves now, maybe we can do a claim, maybe it will find its way to ICC or one of the other institutional arbitration organizations, and then we see what happens. But then what I'm trying to demonstrate is the challenges that an ESG clause like this has. So identifying the rights and or the rights and obligations of the organization is critical, other than say reasonable or comply with. We need to understand which industry are you, what are you doing, and what is the output, and then be able to give the tribunal some meat on which it is going to be able to resolve the disputes. Otherwise, the way we are doing things, we move very quickly. We want to do things yesterday. Sometimes if you do not look at the governance environment, and also now the environment, the social people because the people of Kazakhstan in the initial stages didn't know where the shortages were coming from. If they had thought about engaging with them, let us improve the grid, this is not a problem we would have faced. And also now, the existing framework in Kazakhstan doesn't even assist in having a seat there. So ESG is real, and it's coming at us from angles that we probably have not been familiar with in the past. So that's my 2 cents.
Thank you.
May I add something?
Yes, please, Dr.
I had said earlier that if you're an arbitrator handling a dispute that has something to do with climate, don't just sit there pretending you know what they're talking about. Get the help of experts. And who are these experts? For example, you might want to see a climate change assessment report. And you know that cannot be done in a week or two. It takes a long time. So how many, for example, how many Kenyans are climate change assessment impact experts? In this room, how many? Maybe 1 or 2, and I'm not one of them. And then you might want to see environmental impact assessment reports. And those are detailed reports, and they're not the same, they're not uniform. For example, if you're looking at the SGR from the coast to wherever it ends, each section, say 50 kilometers, has a different environmental impact assessment. The one that passes through a wildlife area, that's different. Where there are animals, that is different. And you need to see those reports, and you need to hear those experts. So where will you get those experts? Because you will not be able to make a decision without that. The rest, the others I can think about is strategic environmental impact assessment, policies, programs, plans. What are governments thinking? There is also the social impact assessment. It has to be done, and a good one, with public participation. There's another one called biodiversity impact assessment. I remember a client of mine was denied a license to have a solar farm because it would threaten a rare spider in South Africa. Just a rare spider. And then he was hitting the roof in my boardroom asking, what is a spider? What has a spider got to do with my money? But you see, it is biodiversity impact assessment. Okay? And it's there, it's relevant. So those microscopic things in the soil, you must take care of them. If it's a habitat, what are you going to do? Who speaks for the animals? Who speaks for the wild? Then there is the heritage impact assessment. If you are building something very ugly here, what about the people who have lived there in peace and quiet? What will you say to them? Then there is the air quality assessment. And air quality, you need to measure it empirically, not through evidence and cross-examination. There's also water quality assessment, and I can also think of environmental valuation. What is the value of the environment, and what is happening if you now put in this project here? And that, again, requires an economist. Finally, there is mitigation measures. What is it you're going to do? For example, if you are putting up a nuclear plant, and there's a lot of nice talk about how we are going to put up some nuclear reactors in Kenya. I'm asking myself, where and how? If it blows up, what do we do? Where do we run to? How fast can we run? And then are there other options of putting it up elsewhere? Okay? And then year after year, how do we monitor across 100 years? And all that is before you, and my answer is you get experts to advise you in simple terms, where are we going? I once got an expert to advise me on biodiversity, and he didn't think I know anything about it. He told me there's no biodiversity in a particular county in Kenya. I gave up. Thank you.
Thank you, Daktari. And I think those two last points by... Okay, yeah.
I just want to chime in to say, well, I'm not an environmental expert, but I belong to a company that does those impact assessments, as well as the testing, the air testing, the EAIs, so the EIAs, sorry. So they are available, and it is possible to get them. If you'll allow me, just one last thing I would like to mention, and I remember that what Dr. Mwigwa was saying, because I think 2 days ago, the Australian Supreme Court set aside a license, or the Australian Supreme Court set aside a license in, is it TB, because of an application that was made by the First Nations Aborigines in Tiwi, and just because of questions of maintaining the social, cultural integrity of their community and how they had lived, and because there was no approval that was sought from them. So this is becoming a really live issue. We're not talking about something abstract or something that is happening in one pocket of the world. It is happening in every single pocket of the world. The last thing I'd want to just mention on the regulatory framework is in respect to investment treaties, the BITs. Many of them have, they have a usual format that we follow. When it comes to dispute resolution, however, there's been a lot of clamor that their governments, they get some of the awards that have been rendered, either at ICC or even at ICC, are huge. It is a private process. The citizens do not get an opportunity to participate or to hear or to know. So there's an emerging question of, do we get amicus curiae? We don't have them at that level. But there's a lot of push for them to be involved in the process, so they can also make their presentations. How are they going to do it? If it is going to happen, it is a discussion that is happening. But now there's also a drive to have the carve-outs to provide for transparency in such treaties. It's good to keep a lookout for that if you're doing international commercial arbitration or even investment arbitration as well. And it will also impact on how you finally determine some of those questions or issues. The Australian civil society groups are very strong and active in that area, and they even have issued guidelines on how human rights and activists should also be involved and included in, but specifically for international arbitration and in the investment arbitration as well. Finally, also homegrown in Africa, the Africa Arbitration Academy has also issued a model, BIT. Some of our people, I don't know whether Noella was part of that team, but I know quite a number of Kenyans were represented. And they have introduced the concept of Ubuntu, which is a very social pillar issue, as well as the environment and protecting the biodiversity of Africa. So familiarize yourself with that because it is going to become an issue, if not today, tomorrow, in the very near future. Thank you.
Thank you, Jacqueline. And just in the interest of time, I know time is not on our side, just as we conclude, so then I would like to ask Wanjiru Ngige, based on everything we've been discussing here, do you think what we have in terms of regulatory regime is enough? And if not, how much should we improve, or what are some of the areas we can look into to improve what we already have?
Thank you, Gordon. I'm not a proponent of throwing more law at a problem. The commandments were only 10. Our constitution has very many clauses. We can't all remember them at the same time. So I'm a proponent of less law. If you already look at what we have in terms of protecting the social concerns in ESG, it's a lot. We have local content rules saying that if you come and run a project in Kenya, you must have local suppliers, you must have local businesses. That's already something we as arbitration practitioners, whether sitting as arbitrators or initiating arbitrations, can enforce. We have concessions which require you to employ a majority of the local population. Things like environmental restoration orders already, those are there, and they are very powerful remedies. Another one I saw the other day is the requirement. I don't know how many of you have been to Thiba Dam in Kirinyaga. I don't know that any of you have seen that, but they have developed irrigation canals for the local community as part of their contract. I don't know whether it's part of their contract or whether it's part of their, but it's part of their contractual obligations, and they have done that. So already, I feel that we have the sufficient framework to actualize some of these things and arbitrate and litigate on them quite specifically. I think if I just add one thing, the beauty about arbitration is it's such a flexible process. If once you sit down with your arbitrator and agree on your rules and your rules of procedure, they pretty much can fit any situation. Thank you.
Thank you, Ms. Ngige. Of course, in the interest of time, we wish we could take all your questions. To me, definitely this is a topic of interest, and I hope we can continue engaging in other platforms. But just as we conclude, maybe I would ask any of my panelists any last burning thought before we can call it a day.
Yes, a lot of us in this room are lawyers, and we have a problem. We think law can solve all your problems, not in environment at all. 100 years ago, this place was clean. 100 laws later, it's degraded. So much so that you wonder, what is the role of law? So I think we must look beyond law to things like ethics, environmental ethics themselves, religion. We must be able to say to someone, this is immoral. Okay, if you look at the East, in some countries, people live with elephants at home, leopards, cheetahs, tigers, and they don't hunt them down. We must look at market forces. Who do we shun in the market? We must look at other instruments of environmental governance, and we must go back to what was here before, the multinational scheming. And what was it? We must look for it, and it's still there, and we must find a way of placing it there within the society. Thank you.
Maybe one last word?
Yes, please.
I think my final word on this is that ESG clauses and ESG arbitration are novel. It's a really new area. When you look at it from the concept of combination of environmental, social, and governance issues. So because it's novel, it's also very complex, it's also very new, the dynamics are also very fluid, and they are largely untested. So anybody who is going to get involved in this area, from whichever angle, you'll be making precedent. You'll be determining how we are moving forward. So some of the key issues that I think the first place we need to start is to look at, and this is really from a governance perspective, to look at lowering the risk of non-compliance, because The non-compliance is what leads to disputes, it's what leads to expensive referrals or dispute resolution. And then, of course, look at a way of having policies, approaches, systems, procedures that are inclusive and also create possibilities for diversity. There's no way we're running away from technology. You, as an arbitrator yourself, please digitize and use technology. Please use Zoom instead of having to go for a physical meeting. I know we are all here physically and we're enjoying it, but we should be looking at the greening pledge to leave a better, a better footprint, environmental footprint. And let's also communicate. The lack of communication is also a big source of the disputes that we have. If you don't communicate with your neighbors, then you will have a problem with your projects. And keep proper records. I know we have a time limit, but if you're in the corporate side, make sure that the records are accurate, complete, up to date, and then make sure that they are in compliance with the regulatory framework. Ethical behavior, ethical behavior, ethical behavior, integrity, 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 integrity. I don't know how we can emphasize that. And we should evaluate on these issues regularly, and where we find gaps, let us train and improve our capacity. Thank you.
Thank you. So we'll stop at that. And thank you so much for your time, ladies and gentlemen, as well as to my panel members. Thank you very much. And we can take our seats.
Okay. Thank you very much, Gordon. Now it's time to call upon Noreen, who is... So I'll just briefly introduce Noreen. Sorry. So Noreen is an arbitrator, and she also sits on the Global CRB Young Members Group steering committee. And she is a senior associate at Triple OK. And her panel will be discussing energy and public-private partnerships project dispute resolution. So on her panel, we have Ibrahim Kito, who is the Chief Legal Officer for Dispute Resolution at Kengen, Kenya, and Doris Mwirigi, who is the Managing Director and CEO at Energy Solutions Africa Limited. So thank you.
Thank you, Enrico. Karibu Sama Ibrahim and Doris. I had switched your name cards, but you can switch them back. So thank you everyone for staying on this long. We've been set as a panel towards the tail end because we're all energy lawyers and we are energetic. So we'll be able to deal with the issues before us. So this panel will discuss energy and infrastructure disputes, and particularly PPPs. And I'll just set the stage and then introduce my panelists and have a few questions for them. So as we all know, energy is a critical component for the economic development of any country. And presently in sub-Saharan Africa, we have the lowest energy access rates. We are also considered one of the most underdeveloped sub-regions of the world. And energy demand continues to grow in the continent just as the population increases. And many African countries have put forward very ambitious plans for economic development, which are highly reliable on affordable energy, sustainable energy. highly reliable on affordable, reliable, and sustainable energy. And we can see a lot of countries, at least in the last decade, have taken up very huge energy projects. For those of you who are aware, Kenya, the Ministry of Energy of Kenya rolled out the energy roadmap for now until 2040. And one of the things the country is looking at is increasing our installed capacity to about 100 gigawatts. We are currently at 3 gigawatts. So you can see the kind of projects that we'll need to undertake in the next 10 or so years, 10 to 15 years. And we can see countries like Uganda and Tanzania picking up the East Africa crude oil pipeline. We see countries like Namibia taking up a green hydrogen project that is supposed to produce about 300 tons of hydrogen. And then we have countries like Angola, Morocco, Ghana, South Africa, Congo, and Botswana, which have in place very huge solar, wind, and some geothermal projects in the region. And the major barrier that African countries see when it comes to energy projects is the lack of capex to start off these projects. And this is where PPPs come in. It's where governments can partner with the private sector to deal with budgetary constraints and build up these energy projects and infrastructure which they could otherwise not do with their own budgets. And we all know that where there are large projects, disputes follow. And we've seen a couple of them globally and now coming up in the region as well. ICC, for instance, noted in their dispute resolution statistics that they had about 167 new cases only in the energy industry. When you look at investor-state disputes, the annual report issued by ICCID showed that 30% of their caseloads are from oil and gas cases, 20% of their caseloads were from electricity and other energy subsets. So we can see that the energy sector continues to dominate a lot of cases in the region and also globally. UNCTAD as well issued notes just last month, and they reported that they have a lot of cases in the fossil fuel sector initiated by companies against states that have passed laws limiting or phasing out fossil fuel investments. We've also seen a lot of proliferation of ISDS cases. These are investor state cases for renewable energy, where governments have sought to limit the tariffs because of the reducing cost of renewable energy. As mentioned by the panel that has just finished, there's also a lot of climate change litigation to limit emissions and to deal with the net zero energy transition. And closer home, of course, we've also seen a rise in energy and infrastructure disputes. And here, of course, I have with me experts whose sandals I am not fit to tie. And I have the pleasure of having Doris and Kito on this panel. And I'll just allow you a few minutes to introduce yourselves, the institutions you come from, and what you do on a daily basis.
Thank you, Noreen. It's so good to see you and to see the strides you're making in the sector. So my name is Doris Mwirigi. I'm an energy lawyer. I run an energy consulting firm, Energy Solutions Africa Limited. And I also wear another hat. I'm the vice chair of the Energy and Petroleum Tribunal, a tribunal that is formed to hear that sits in the judiciary that hears matters specific to energy and petroleum.
Okay, thank you, Doreen. By introduction, my name is Hibran Kito. To start with, I'm actually a lawyer first. I currently work with the Kenya Electricity Generating Company, PLC, which commands 80% of the power generated, 90% of which is green, and at least I can confirm 80%, literally the power you are actually consuming in Nairobi is generated by KenGen. I serve as the Chief Legal Officer in charge of projects and disputes resolution in KenGen, and of course dealing a lot with projects, not only in terms of disputes, but also structuring the transactions, disputes avoidance, and of course general litigation. Of course, beyond that, I have also been privileged to serve in the board of the Chartered Institute of Arbitrators, the Kenya chapter. And the humanity side is that I also serve as a board member with the World Vision Kenya. So that is me, but of importance, a lot of passion for projects, infrastructure, and of course, disputes resolution, coupled with projects governance. Thank you.
Thank you, Kituro and Doris. In terms of the work you do, what are the kind of disputes you see being brought to the tribunal? Of course, Kito, from KenGen's perspective, and to what extent has ADR been employed in the resolution of those disputes?
Okay, I will want to identify 3 areas of focus in terms of the disputes I interact with, and I will speak generally and also specifically to the energy sector, electricity side, because I know Doris will be here to speak about the oil and gas. Most of the disputes I've actually interacted with span majorly on projects. And for these, we are looking at majorly public procurement related disputes. And it's good for me to put a cap in terms of what disputes, when you talk about public procurement disputes, we are looking at disputes which speak to how the procurement process has been done. And these are disputes before a contract is actually signed. So in terms of those kind of disputes, my comment will be that arbitration appears to be a stranger to that kind of a process. And it's for obvious reasons that there's a public policy aspect of it, in that disputes relating to public procurement proceedings are actually legislated, and the relevant law is, of course, the Public Procurement and Asset Disposal Act for 2015, and of course the regulations for 2020, which now, of course, they create the structures of disputes resolution, one of which is, of course, making of an application for review before the Public Procurement Administrative Review Board, with a judicial review against the decisions of the board going to the High Court, and of course the Court of Appeal, and of course matters of significant importance, they can all go to the Supreme Court. In terms of how many public procurement matters which have actually gone to the to the Supreme Court, I think I cannot remember one. In fact, I had a case I was waiting for the jurisprudence to be tested at Supreme Court, but we did not get an opportunity of it going to the Supreme Court. So that is in terms of the public procurement. But then it's important to mention that arbitration kicks in terms of contracting. Once you've already contracted, then to that extent, then contract in itself, the contract which is already signed between the public entity and of course the contractor, can make provisions for arbitration, and often actually arbitration is actually one of the methods which is usually stipulated for dispute resolution for public procurement matters, but then when a contract has already been signed. The other thing I'll be keen to mention is that beyond the public procurement, and I think in terms of discussion as to whether arbitration or ADR is actually applicable in terms of public procurement proceedings, I will invite you at your own time to look at an article we've actually written with Dr. Mwigwa on arbitrability of public procurement proceedings in Kenya. And in that article, of course, we are trying to look at what are the arguments for that and what are the arguments against it. I'll be keen to mention that looking beyond Kenya, UNICITRAL actually accommodates ADR for public procurement proceedings, and countries like UK and Poland actually appear to accommodate that. But in Kenya, we are yet to test that kind of practice. The other kind of disputes we also look at are actually disputes affecting a project when it's under implementation. That means you already have a contract on board. Maybe a contract has actually been signed based on FIDIC, whether it's a gray book, yellow book, so that to that extent then the process is that we have what we call, and this is actually anchored in Public Procurement Act for complex projects, we have what we call project or contract implementation teams. These are actually like the teams which will deal with disputes before they emanate, or rather before they become ripe for adjudication or arbitration or even litigation. Then of course beyond that we have the DABs, disputes avoidance, adjudication board. And of course recently we are talking about disputes avoidance and adjudication boards. Then of course we have arbitration, which sometimes can kick in. And of course we also have other mechanisms we call expert determination. The other one I'll mention, which is also now beyond not only about the energy sector, is of course what we've seen in terms of investment, whereby because we are talking about energy transition, there is a lot of participation of independent power producers in the energy sector and the energy space. And what is happening is that, like one of the presenters was actually mentioning, the issues of investor treaty protection comes into place. And one of the key things which is actually happening is the issue of investor treaty protection, but at whose cost? Should we merely allow investor protection to the detriment of our right to sustainable development, our right to regulate, especially in terms of things like Dr. was talking about, environmental issues? So there are also disputes in that context of investor treaty protection and the aspect of the BITs. And I was listening as Jacqueline was talking about the model treaty, which has just been developed by the African Academy, which now appears to balance the two often conflicting sides about investor protection and then the state's right, sovereign right to regulate. So there are a lot of disputes surrounding that, and I think closely related to that is what we basically saw the other day, whereby the government actually made some attempts to do what we call an attempt towards a review of the power purchase agreement, which the government had already signed, government of Kenya signed with the off-taker, that's Kenya Power, of course backed by the government of Kenya, had actually signed with the IPPs. And that speaks to the challenges we've been able to face in terms of pushing that forward, speaks to the issues of BITs, because some of those IPPs have actually, in most cases, they have shareholders who originate from countries Kenya has actually signed BITs with. So anytime you try to undo or to undo or even do an override on the contract unilaterally, then the issue of investor treaty protection kicks in. And of course, the doctrines of pacta sunt servanda, that what you signed at arm's length can actually not be undone unless if the parties are willing. So there are those kinds of disputes we've been able to interact with. Thank you.
Thanks, Kito, for that comprehensive breakdown. Doris?
I think first to start with the tribunal, I think the disputes, to understand the role of the Energy and Petroleum Tribunal, you would have to look at the role of EPRA, who is the regulator. So the mandate of the tribunal is to hear all disputes from the regulator. So what if you're dissatisfied with the regulator's decision, then you come to the tribunal. So you find that the regulator grants all licenses, anything regarding the petroleum regulator. So if you're dissatisfied, you come to the tribunal. If you're also dissatisfied with the decision of the minister, for example, in issuance of geothermal licenses, you would also come to the tribunal. If you're also, and then we have original jurisdiction between licensees and third parties. But the kind of matters that are now at the tribunal, the bulk of them actually have to do with electricity. So a lot of disputes relating to Kenya Power, many people dissatisfied with Kenya Power and also from the regulator for cancelled licenses. So then when I speak about what I practice, which is petroleum, as Kito said, now in terms of petroleum, upstream, you'll find that we are the biggest uptakers of arbitration, whereas other sectors are struggling with ADR. In petroleum, it's almost automatic. In fact, if you look at the Petroleum Act, Section 117, you're mandated to first go to ADR. you cannot take a dispute. It's compulsory that you do ADR under Section 117 of the Petroleum for petroleum matters. So you see that in upstream petroleum, ADR is compulsory. So you first go to the ADR before you go to dispute. And if you look at upstream, rarely will any matters go to court, very rare. All matters in petroleum are usually through ADR. And then when you look at for example, the model agreement, which everybody must sign for upstream, there is already a standard arbitration. You must go to arbitration, and unicitro is so in this area. Whereas energy, there is a lot of this other, you'll find a lot of legal litigation. In petroleum, you find it's purely ADR, a lot of ADR mechanism.
Thanks, Doris. And just to stay on with you, you've mentioned the kind of disputes that the tribunal receives.
Yeah.
Does the tribunal have any mechanism or structure to introduce ADR when the matters have been brought before them?
First, when you look at the matters, by the time, you see, because you're the second phase, by the time people are coming to you, very unlikely they will want to negotiate, to go through, they will want to go through ADR. So you find they've already gone through the regulator and ADR. In fact, there's one matter we have encouraged them, and we were hoping yesterday they'll come back with a concept so that I would report today. And we are mainly encouraging alternative dispute resolution, especially for cases like electrocution, those matters with Kenya Power. So there is no mechanism, but we are encouraging, and like there are two matters where we are actively encouraging them to use ADR, because like matters of electrocution, those ones, people are already hurt, you don't want to continue with this process. So yes, but it's not mandated, it is us encouraging them to go through the ADR.
Okay. Great.
Just to mention one thing, and I like what Doris was actually saying. One of the things, and we need to bear in mind that the public procurement aspect, the public procurement regime actually applies across all the sectors for as long as an institution is actually public. One of the things which we find unique is that, unlike cases like matters to do with tax, and of course matters to do with the mainstream oil, in terms of public procurement, definitely, like I said, the issue of arbitration is almost a no. But when you try to juxtapose the Kenyan situation with the unicitral model for 2011, and of course countries like Poland and UK, they appear to actually create a situation whereby if a bidder is actually not happy with an award, then before you go directly to the review board, there is a period of, I think, 7 days, whereby the bidder is allowed to interact or do exchanges with the public entity, so that if it's an issue they can be able to amicably resolve, they can. And why I'm thinking that this is actually a very important thing to speak about it, because there are times an evaluation can actually be done and immediately an award is out and regret letters are out. Issues arise which actually can be able to be identified as very genuine cases that actually this award was awarded wrongly and genuinely. Now the problem with the current legal structure is that because of the way the law is anchored and the fact that it doesn't provide the public entity and of course the winning bidder and the one who's actually lost to be able to explore ADR, and of course it's because the tripartite nature of the arrangement and the public policy aspect, because here we are talking of more than two parties, you find that a public entity may be forced, or actually it's forced to go and litigate that review, yet clearly you can tell that you are going to lose. So my argument has been that if it were possible to introduce not really arbitration but ADR in the context of such an issue arise, then the PE should be allowed to reach out to the two other parties, come to the table, and sometimes it's a genuine case. Even the winning bidder can actually clear it. This one, for sure, I did not win. And I'm speaking from experience, it has happened. I think our procurement law needs to contemplate and actually take those kind of scenarios. But then one thing to speak about is also the ADR and arbitration in the context of the public-private partnerships, which is now the other regime of procurement, of course informed by the need to be able to deliver in structure beyond the balance sheet. So of course we know that we have the public-private petitions committee, which is the equivalent of the public procurement administrative review board, but now on the public-private partnerships. Something very funny is that we've had a scenario whereby we had such a matter touching on a PPP project, and you'll be surprised that a council went to the procurement board as opposed to the PPP petitions committee. That shows you the level of ignorance which can actually exist. Looking rather obvious, but I will tell you it can happen. So what I can say is that there is a lot of discussion and understanding and even jurisprudence which is being churned day in, day out in terms of public procurement matters, but in terms of public-private partnerships, we are lacking that, and obviously that can be explained by the fact that the public-private partnerships regime is still new to Kenya, although now with the new act we expect that we are going to see it gain traction. So the same scenario you are seeing under the public procurement also exists under the public-private partnerships. There is no room for ADR, there is no room for arbitration, there is no room for mediation, conciliation, whichever, at least at the procurement stage. But of course, after a project agreement is signed, then of course, all those mechanisms can kick in place, depending on how the project contract is actually now structured. Those would be my comments.
Thanks, Kito. And just on that PPP perspective, there's this notion that arbitration is ill-suited for PPP disputes, especially when they have, that public component, and there's need for transparency to understand what government has entered into, what the terms of the contract are, and so on. I don't know what your views are in that regard, and whether you see there's need for reform when we look at our PPP Act.
Doreen, you're actually speaking to my heart, and in this way, like I said, for those ones who like reading, if you get time to look at the journal article we wrote with Dr. Muigwa, which is actually in the last issue under the NCIA, it's available actually online. Those are the arguments we are saying, that the traditional position is that public procurement proceedings and public-private partnerships are not ripe for ADR, they are not ripe for arbitration. But then there are these things to speak with the public procurement principles, Article 227(1) of the Constitution, in terms of Article 10, even in terms of accountability. And then the discussion currently is that it is no longer time to speak about confidentiality. It's no longer time to speak about parties being two. It is time to say it is public. And to that extent, then there are discussions that we need to find a way in which we can bring in these unique cases whereby then arbitration and ADR can actually be accommodated within the public procurement, the conventional public procurement, and of course the public-private partnerships regulatory regime. At least, if not for arbitration, at least to inculcate ADR at the point just before the matter is actually taken before the relevant committee of the relevant public procurement administrative review board. But at least the beautiful thing is that for as long as you have the contract, now you are speaking about disputes beyond the contract, then arbitration ADR is applicable for as long as the parties have been able to mainstream it within the contract. Yeah, but I'll say discussion is ripe towards introducing ADR, including arbitration, into resolution of this kind of dispute. It's no longer time to talk about, how many parties involved. So in fact, different from what most people will argue that public policy, informed by the law the way it's structured, the discussion is that actually public policy dictates that we need to go the ADR way. More so if you are to realize the constitutional tenets under, is it Article 159? Yeah.
Thank you. Doris, back to the tribunal. So the tribunal was instituted to ensure that disputes are heard faster, efficiently, but also by industry experts. But the Act allows for parties who are aggrieved by the decision of the tribunal to now appeal to the High Court. Do you think this negates the purpose of establishing the tribunal in the first place? or should we rethink that section of the Act?
I don't think it does, because I think it's just giving any person has a right to appeal, and to exhaust all the legal mechanism. And as you said, our tribunal as experts. So one of the things that has happened is, because we have power engineers, we have 2 engineers there, so we are able to deal with the matters in a more technical way. You'll be surprised to date, there hasn't been any appeal. Yeah, but even if there was an appeal, what they are now doing, the tribunal has introduced also, the Office of the Registrar of Tribunal, is the case back. So that if any matter goes to the High Court, then it is sent, the decision is sent back to us, so that we understand, if it's not upheld, on what basis or what. But you can bet it wouldn't be on technical matters, because there it's where we have the technical expertise. But I think it's a good thing, because you are the litigant, you have a right to exhaust the legal mechanism. And what we're doing is that because we are very fast, all decisions, we are finishing matters within 3 months or so, then it helps you, even if you're appealing, then if a decision has been done within 3 months, you go to the appeal, how long will that take? So I think it's a good thing, if you ask me, so that then you exhaust the entire legal mechanism.
Thanks. I don't know if Kito, you wanted to add something to that.
Yeah. I was waiting for Doris, and perhaps not to take the risk of preempting it, if she had it in mind. Perhaps Doris would have also told us something we've been discussing with her in terms of some provisions under the Energy Act, which actually appear to give the tribunal generic powers, powers which are so sweeping to an extent that they can even assume jurisdiction on matters affecting, contractual matters affecting energy sector player and maybe licensees, including the public procurement matters. So perhaps Doris can comment on that. But as she comments, speaking to the issue of energy transition and speaking to the issue of moving from the traditional forms of energy, that means the likes of hydro, the likes of, what we were used to in the 1990s when there was a lot of power rationing. There's an emerging discussion surrounding how fast we can move, especially when you are private players invited with an objective to spur energy transition towards a renewable energy. But then the situation has been that much as, of course, the environment is so attractive for them to come in, we are not seeing anything on the ground in terms of them being able to develop the power plants and see them on and going. Licensing issued, project agreement signed, a decade down the line, nothing is on the ground. But then what an IPP needs to do is to wave, the card of, you are breaching my legitimate expectation by revoking license, yet they are not able to move and be able to live to the expectations of the license, the conditions of the license. And for this, I'm looking at instances of delays in terms of being able to be on the ground and develop power plants, so that then we can have what we call early completion commercial operation dates. That means not only giving you a license, but you need to do what you are supposed to do as per the license conditions within the shortest time possible, so that then we can have more megawatts on the grid. So what has been happening is that, speaking to a recent case, the Wallam case, which went all the way to the ICC, that was actually the situation whereby people just come to prospect. Once you get the license, nothing happens, you don't meet the conditions, both in terms of even environmental compliance, which Dr. was talking about, but then you still want to remain with the license, that block can be given to somebody who can be able to move faster. That appears to be the situation obtaining on the ground. And what is happening is now, we are likely to see, and because more IPPs are coming on board, we are likely to see a lot of litigation surrounding the right to legitimate expectation and issues to do with the bilateral investment protection the way we were speaking. And I think the case of Walam, for me, it's a good case because it sets a higher threshold in terms of how energy transition to renewable and adding more megawatts through renewable energy needs to be done. And the position as laid by that case, the jury is still out because it's subject of an appeal before exit. But the current position is that we give you the license, there are laws to comply with, there are conditions to comply with. If you do not comply with, the same way we gave it to you, we'll take it back and we can give it to people who are willing to comply. I think the message and that decision specifically, it's a decision we are proud of as a country because it means that Kenya means serious business in terms of energy transition and compliance. Thank you.
Can I comment on that
Yes,
Walam case?
Go ahead.
I think even for what it said, I think that Walam case also is important for the growth of the space. Because when you look at even who represented Kenya and everyone, it was Kenyan lawyers, which was really good. And they put up a very good case there. And it shows the growth of, the arbitration space and the lawyering space, if there's such a word, in Kenya. And also it calls into question, I think, to think about case management and also having, and one of the things that we are now looking at as we advise in the petroleum is having dispute lawyers as you draft the contracts. When you're drafting contracts, especially energy matters and petroleum, there's a lot of excitement because government wants, energy projects to kick off, the petroleum projects to kick off. And rarely do we look at the arbitration clause in energy matters. It's overlooked. So there is need to have the dispute lawyers who we may or not like in the room to just check that arbitration clause, in the case of a dispute. In the petroleum sector, however, when you look at, having been doing petroleum all my life, the arbitration clause is one of the most negotiated. There's a contract we did for petroleum, and that clause was negotiated for around 6 months, just the arbitration clause. So there's a lot of growth in petroleum for ADR and arbitration, whereas when we look at energy, where Kito sits most, is the arbitration clause isn't as much looked as it would in the petroleum, because upstream you see the shells, these upstream companies don't want to go to court. They don't want to go to court at all. So they will spend a lot of time on ADR issues. And I think that Walam case has brought up the importance of all these things, how you draft your arbitration clause, there was also the question, was it actually a license, what kind of license had been granted? So I think it's a very good case for this space.
Thank you. And just speaking about arbitration clauses, and also both in energy contracts and in PPP contracts as well, because of the length of time of the contracts, there's this practice to include a period of time either to cool off or to have mandatory negotiation or to have mandatory mediation before now you proceed to arbitration. From your experience, do you think those cooling off periods work? Should there be sanctions if those mandatory negotiation or mandatory mediation is not dealt with? What has your experience been?
Okay, Doreen, what I can confirm is actually cooling off period is actually very important, and especially for strategic projects. Personally, that's something I literally interact with, if not every week, every 2 weeks. And one of the things I will tell you is that for the last 3 years, I've gotten an opportunity to be able to deal with what we call cross-border transactions, whereby we have projects we are doing outside the country. Right now, we are not the ones procuring. We have actually been procuring. So it's a case of you are used to wearing the shoes. Now it's the other person. Actually, there's a standard you set for the other person. Now those standards are being set for you. Those standards are even crazier when the other person is actually private, because public, it's easy to deal with. And let me give you my experience with one of the projects in terms of the issue of cooling period and why it's important. If you set arbitration or litigation as a default method of resolving disputes, then basically what you are saying is that you do not want any project at all. Because I will tell you, certainly in a project, some things will come out, and it's only somebody who has a keen mind who will be able to pick it and say, this is not a dispute, this is a claim. And because it's a claim, in other words, you are saying, inidome. This one we can sort at the level of people on the ground. So now, my proposal, and I will also say which is the corporate proposal, is always the need to have a tiered kind of approach, whereby you have I would call it dispute resolution mechanism, but I'll have a claims resolution point. Now there you are speaking about ADR in terms of mediation, soft discussions between the projects team, that's people on the ground like myself. Then from there, you escalate. Of course, with very clear timelines, because you have to be clear in terms of timelines when and how it needs to be done. You can escalate that to the respective CEOs between the two companies. Also with clear timelines, because if you don't put clear timelines, then you are saying that that project is likely to find itself bogged by indefinite time in terms of dispute resolution. Then after that, then you can progress to aspects to do with either adjudication. You can choose either adjudication. Because of the specialized nature of energy, I usually prefer expert determination. That means somebody highly experienced in energy matters. Perhaps if it's something to do with civil works, it must be a civil engineer, somebody exposed with engineering, technology, all those kind of things. But it must be an experience speaking to the contract at hand. That means it may actually be a dispute, but you may not see a lawyer there. Perhaps because the issue at hand doesn't need a lawyer. But in most cases, it's preference to have diversity of skills so that then you are able to get best of the both worlds. Then from there, of course, then you can progress to litigation if things cannot be resolved. But I'll tell you that from a project perspective, multi-tiered dispute resolution structure is always recommended, but with clear timelines and clear expectation in terms of how many experts, who will appoint them, within what timelines, they also need to make the decision. Because if you don't dig deep into those details, then immediately the parties are in dispute. They cannot have time to even think through and also agree with each other. But once you have it at the start, then you already have been able to determine the level playing ground. For the softer contracts, mediation can be a preferred way. And of course, after mediation, you can just talk about dispute resolution through litigation. Yeah, but it's case-based. If it's a strategic project, then you have to think through very clear mechanisms. And of course, for especially the local contracts, NCIA, the circular from the Attorney General dictates that you have NCIA as your default place, and of course, the default rules to apply. So it's a cocktail, depending on the circumstances and of course, the peculiarities of each project or contract.
All right, I see Wanjiko telling me that I need to wrap it up. Any last parting shots? Doris, Kito?
I just wanted to say that having worked with in the Now Tribunal with the experts is saying, I've really seen a big difference. There is I think there is room for non-lawyers in this dispute resolution mechanism, and it's really been useful. Just to comment that we are going to the next phase, as some of the former panelists mentioned, that there is a lot of energy and petroleum projects that are going to be taking off. So I think it's a good time for members to familiarize themselves with the space, so that then we can contribute to the space. I think it's a growing space, and growing even more with the new projects that you have mentioned that are coming up in Uganda, Tanzania, and in Kenya. So it's a good space to familiarize ourselves with so that we can participate in the sector.
Yeah, I will just speak from what Doris has actually said. When I joined the energy sector, and maybe stretching because I've also had an advantage of working in the oil and gas.
We worked for the same employer.
Yeah. One of the things I noted that I thought it was actually an easy ride, and I'm actually doing my 9th year now in oil and gas and energy. And one of the things I've been able to pick is that as a lawyer, you really need to have resilience. You really need to have determination and focus towards, becoming, or rather being able to understand the nuances of the sector, because it's quite complex. And one of the things I'll encourage, especially the private practitioners, is that don't just say that you're an expert. Take time, understand the sector very well, understand what is a PPA, understand what is, all these things we are talking about, reforms, about the review of the, IPP, PPS, tariffs, because it's a complex area, and especially the projects aspect, so that then, should that opportunity arise, then you become the to-go lawyer for perhaps any lawyer working in-house, because that is always the biggest challenge. Sometimes you'll actually get a dispute, but then you realize that within that dispute, there's a procurement issue, there's an complex arbitration issue, and I'm actually seeing one of my service providers around, because you usually have those discussions that, as a client, I want the best from you. I don't want you to give me less than what personally I'm able to give. I want you to give me more. And of course, with that, there's an expectation that you have to deliver, and for you to deliver, you really need to understand the sector, so that even as we are discussing about me coming out and saying I can do it, you need to give me a reason as to why you can actually do it as opposed to me. That means it's time for us to create that, to do away with that information asymmetry by interacting, and I think through forums like this one, so that then I can be able to understand exactly what is a private practitioner looking at, and you're also able to understand what I'm looking at, maybe from the general counsel perspective. And of course, the message is that there's a lot to learn, and if at all you are cut to understand a particular sector, much as of course lawyers, we want to do everything, try to be known for something, and that of course requires a lot of focus and a lot of need to learn. And I think sometimes that learning can only be done if you have those frequent discussions with the client, people who are actually doing it every day, so that then you'll be able to deliver the services as expected. And of course, you can get that bite of the pie.
Thank you. That's a good place to end this panel. Thank you so much, Doris and Kito. My deepest gratitude for availing yourselves and even sharing your experience and your wisdom that you've gathered over the years. Thank you. Wanjigo? Is she here? Okay.
Thanks, Noreen. Okay. I think there is coffee and tea at the back, if I'm not mistaken. So as we set up for the next panel, you can go and just grab a cup of coffee, get some more energy in you. So our last and final panel for the day is going to be moderated by Miss Mercy Okiro. So, oh, yeah, you are. Okay. Mercy has one panelist who will be joining us physically and 2 panelists who will be joining us online. So Diane Okoko and Emilia Onyema. So here we have Mercy and Cecile. So Mercy Okiro, our moderator, is the Vice Chair of the National Construction Authority Board, and she's also the Vice Chair of KEPSA Gender Board. She's also a member of the ICC Arbitration and ADR Committee. And I will let her just give a very brief introduction of her panel members, and then we can proceed.
Good evening, everyone. I know we are all tired, but let's try and power through. At least it's a Friday. And of course, I've been trying to follow some of the panels online, and I've learned a lot. I also did manage to attend the training yesterday. The panelists' profiles are going to be projected in the course of this panel, and in any event, they'll be circulated by Lloyd. That is one of our members and support for this conference. However, they are all personally known to me, so luckily, I was not prepared to do this part, but I'll do it because I thought it would be projected. But nonetheless, I'll start by introducing the person who I'm with physically here on to my left, Cecil Kuyo. He's a partner at Bowman's. I know him. He's also a qualified arbitrator. And he also dabbles in construction adjudication, but he's an astute dispute resolver with knowledge in various realms of the dispute resolution spectrum. So welcome, Cecil. And also he's my friend. Everyone on my panel is my friend. So next I'll introduce the person I see directly on the virtual screen. That is Diane Okoko. Diane Okoko is a partner at Marcus Okoko and Company. You can clearly see, based in Nigeria. They have offices all over West Africa, and notably Abuja and Lagos. She's also a fellow of the Chartered Institute of Arbitrators, and she's a lecturer. That is, she teaches the same. She's an astute also litigator, but of late she's leaned more, in the last few years, she's leaned more towards ADR. She's qualified in very many areas. How I know her, that's enough. Last but not least is Professor Emilia Onyema, who is also my friend. As I said, everyone on this panel is my friend. Dr. Emilia, doctor and also professor, is a lecturer and an arbitration leader. Really, when I think about it, she's a leader because she's at the SOAS London, and also she's recently, Prof, if I'm wrong, kindly correct me, visiting fellow and professor at Oslo University. I like you're giving the side eye, like, don't mess it up. I will not. And of course, she teaches a lot of people. She's also an astute dispute resolver. And also when you see, you learn that in 2nd November, we have the SOAS African Conference, Arbitration Conference, which is usually an annual event. She's the organizer, rather, she's the one who started that series. This year it's going to be in Ghana. I'm just plugging that in there real fast as we move on. Okay, I think I've done the introductions to my best of my ability, and I'll quickly jump into this panel because I know time is of the essence. And I will start with a few questions as we look at the evolution in arbitration, either areas that we already know or areas that existed before, but now we are thinking about what has changed, and is there going to be evolution? Is there any dynamism, or are we just going to stay static? I will start with, of course, posing a question to Dr. Emilia. One of the main, and I'd say main because Nigeria is a key player in the Commonwealth countries in Africa in arbitration, one of the key developments this year has been the passage of the Arbitration and Mediation Bill in Nigeria, which has now passed into law after several years of lobbying for the same. Now, Dr. Emilia, what are the key features you'd say of this act, and do they then set up Nigeria now to be the rightful seat as it should be? I'm not saying Kenya is not, but you know what I mean, in terms of course, having this law passed in 2022 after all those years of clamoring for the same. Thank you.
Thank you very much, Mercy. Thank you to the organizers. We've been waiting in the wings, so I'll just say a huge thank you to everybody for the opportunity to speak. A quick answer, Mercy, is that the bill is not law yet. It's still a bill. And the way Nigeria, the legislative framework works is that when it's passed by both houses, it then goes to the president for assent. And it's still with the president. And the way it is looking, I'm not sure that it's going to become an act before we get before the elections, and hopefully would have a new government in place. And what that would then mean is that it will start life afresh. And so it would get an opportunity, it would have to go back because we would have a new legislature in place. So it is a bill, it is not law. And with that caveat in mind, it's a bill that updates the Arbitration and Conciliation Act, which we've actually had since 1988. So we have a revision of our laws, as in every common law jurisdiction, which is why it's termed a chapter in the revised laws of 2004, but it's actually the ACA was first enacted in 1988. So over time, it's been a long time coming. But the core things that stand out for me, and I still have some queries, even with the new act or the new bill, is that for me, one of the major things that stands out is that we have a definition section, so it clearly defines things, is much more detailed, and it's taken into account where the law has progressed. So there's been some evolution, if you like. I'm quite pleased to see that the seat theory, so the fact that the law of the seat governs the arbitration agreement is clearly stated in the law. So the confusion we have here in the UK shouldn't happen under the new law. In the current version, we do not have a clear statement to that effect. And so what the working group or the drafters have done is they've sort of looked at case law and where there's been lack of clarity in the old law, and there's been judicial activism, and they've tried to plug that. So I'm sure some of you would be aware that under the current system, the Limitation Act, we have case law to the effect that your Limitation Act begins to count. Okay, I wanted to be sure you could still hear me. Begin to count right from when the substantive cause of action started, which is completely ridiculous because, of course, then it does not recognize the fact that the award itself has its own, is a debt, and so should have its own cause of new statute of limitation impact. And that's been clarified in section 34. The seat theory is in section 32. The new act, when it becomes law, sets out the powers of the arbitrator. So by the time you're reading it, you see complements, you see borrowings of wordings or phrases from the English Arbitration Act, from the revised model law, and the laws of other jurisdictions. It includes consolidation, concurrent proceedings, joinder of an additional party. And those are really important for any modern regime. It also makes provisions for an emergency arbitrator, which is really gratifying to see. And when it talks about recourse against the award and has a separate provision for enforcement, recognition and enforcement, and when you're challenging recognition and enforcement. And it then deletes the common law requirement or ground of error on the face of the award as a ground for challenging the award. And that's a common law ground. And incidentally, it's in a subtle way, they've removed any reference to misconduct. Any common law lawyer knows that anything falls under misconduct. And so if you can't find anything, you latch onto misconduct of the arbitrator. And I think that's really important. And then for setting aside the grounds, even where you can prove, and this is influenced by the English Arbitration Act, Section 68, even where you can prove one of the grounds to set aside the award, you have to show that you would suffer substantial injustice. And that is really important. So you can see that what they've done is to try and limit the incidences of recourse against the arbitration. They've sought to reduce the time limits for various activities. I think one of the most standout provisions is a new provision under Section 56 on the Award Review Tribunal, which is interesting. I don't know any other law that has that as part of their substantive arbitration law. And the idea with the Award Review Tribunal is something like the ad hoc committee of ICC, where the parties can agree that this Award Review Tribunal will review the award, so they can seek to challenge the award before a new set of tribunal or the same tribunal, but they will make that decision in the first instance. The attractive thing about it is that if they've made that decision and they've decided that the award stands, then there's even more limited grounds on which you can challenge that decision. I don't know how it will work in practice, because what we don't want is that to be a precursor to going to court. So quickly, to round up, is the fact that I think what this new law says is that for each jurisdiction, you need to be able to identify what is it that is clogging up the wheel of justice delivery through arbitration in your own jurisdiction, and then see whether you can fix it using the legislative tool. In Nigeria, in my my opinion, is that we do need the judiciary to step up. That is a huge disconnect, and it's not because of anything peculiar. It's just that the whole legal system is broken. So I would stop there.
Thank you so much, Prof. I think by now everyone who didn't know much about the Nigerian Act, impending Act really, has learned at least the new proposed one. I'm half Nigerian, so I knew. My honorary citizenship still exists. I'll do a quick segue to Diane now. And Diane, my question to you is, of course, we've attended enough conferences where we've had technology in arbitration, and of course, post-COVID-19, technology has been embraced, but then also there underlies a mandatory duty of tribunals, parties, counsel. There's a duty of confidentiality. Now, when you go online and use all this technology, what do you think we as the arbitral community, specifically in Africa, can have as our key considerations to tackle and also perhaps address ourselves to developments in cybersecurity? Thank you.
Thank you, Mercy, and thank you to the organizers. The thing is, when Mercy says that she has that citizenship, she actually isn't joking. The Nigerian government is so scared of Mercy's threats to becoming a Nigerian that has standing citizenship is actually just there and waiting. So I'm going to be more optimistic than my big sister, Professor Emilia, when she says that, she's not hopeful that that bill will be passed into law before the end of this administration. We're keeping 2 fingers crossed and praying and hoping and doing some fasting in between, to have it passed before May 29th. So, Prof, we will be looking to invite you for the unveiling of that act. Right, so back to Mercy's question, we cannot run away from the fact that regardless of all of the downsides of the pandemic, it really could be said to be some sort of it was a plus to the arbitration community in the sense that given that one of the biggest pillars of arbitration is flexibility and running away from humongous costs that years and years of litigation would have made us to incur. One of the attractiveness of arbitration and maybe most of the ADR mechanisms was, cost saving. So as soon as COVID, the pandemic hit, and we all went back to our screens, it kind of saved, it saved us the cost that we were running from. But be that as it may, it did save us the cost, but it posed another challenge, maybe bigger than even the expenses we were trying to run away from incurring. It posed a threat on one of the essential pillars of arbitration when it came to international commercial arbitration, and that's confidentiality. We will not kid ourselves by saying that there are certain companies who would not do arbitration, even with all of those humongous costs, because of certain levels of confidentiality that they enjoyed with arbitration. Regardless of the cost, they'll go there. But when you have cybersecurity threats, that pillar is challenged, and is challenged seriously. So the question we need to ask ourselves now at this point is, cybersecurity, how much are we even ready? I listened to Dr. Muigwa when he spoke about, getting experts, when he talked about making sure that you know about ESG, regardless of the fact that you imagine there are peripheral issues, you must get experts. And, I lend my voice to his in saying that when it comes to cybersecurity, as practitioners, we should have, if nothing else, the peripheral knowledge. We need to tell ourselves what it is that we may be facing the threat of when it comes to cybersecurity in arbitration. And thankfully, in recent times, and maybe just last week during the ICA just concluded, ICA Congress, the 2022, I don't know if that's, there's some, a playback, there's a playback.
And we can hear you just fine. There's no playback on our end. Thanks.
Okay, so the 2022 edition of the ICA New York Bar protocol on cybersecurity, was just launched. And beyond ICA, there have been the African Arbitration Protocol on virtual hearings, the IVA cybersecurity guidelines 2018, the Delos checklist, the CIR, quite a number of these. But if we dwelt on the ICA protocol in particular, the ICA protocol speaks mainly to the unauthorized access, confidentiality in the process, the integrity of the process, and how this is impacted by cybersecurity breaches. But let me speak to the 8 areas that the protocol really dwelt on. First and foremost, it talks about knowledge. The practitioners of arbitration must have certain levels of the knowledge of cyber breaches. What this means is that regardless of who it is, the counsel, the arbitrators, the clerks, the case management team, every single person, including the staff of the institution or the maybe documents management company, the third party provider, they should have certain levels of this. And very quickly, we need to understand that once there is that breach, it goes to the total integrity of the process, right? So we should be looking at knowledge of the practitioners. We should also look at the asset management. Now, you need to classify what the risk profile of this arbitration is. That way, you know how to organize, how to look at the asset management, how to look at the calculation of the risk of these assets. Also looking at access controls. So the user should be given certain levels of unique IDs or passwords, to have access to this. But that also behoves on the users of the process, be they arbitrators or the council themselves, to be sure who they need to give access to. Then if I took a poll in the room and said, how many of us even seated in this conference know about encryption? So we hear the word and we know, but how do we know how to interpret how secure certain levels of encryptions are? The AES, for instance, the DESs, for instance. How many of us know how to determine for our clients, those of us who are acting as counsel, how many of us know how to determine for our clients which particular provider has the best level of security for this particular arbitration based on encryption? So looking at things like communication security, right? So everything is going digitally. So even this conference is being live streamed, right? And then there are certain things that are going to be said, certain proprietary things. Who do you know is listening at some point? So you need to be sure. Email trails, for instance, who has access, who doesn't have access. At what point is it sitting on the server of maybe a law firm, for instance, and then it's open to security breaches. Then the physical and the environmental security. Now, this is kind of tricky because we're saying we're running away from the physical, isn't it? But the protocol has put in place the standard for physical. What this portends is that physical access to arbitration information. So remember that even the laptop that I am using is a physical asset. So at what point can my laptop be moved or be accessed by someone? So that now marries the digital access with the physical access. And then operational security also, this is about the integrity of the platform. So remember I talked about the knowledge and education of all users, right? So at the point of even choosing the platform, you have the Opus 2 platforms, so many platforms, even the Telos platform. Which one are you sure is the best suited for your arbitration? So you need to look at the integrity of the platform, what's the reputation, what are the reports saying about the platforms. You need to read their vulnerability monitoring and auditing reports because they are obligated to have these reports. So you need to read them and understand what this portends for the arbitration. And then information security and incident management. What is the protocol for that? So if we looked at the, let's bring it home. If we looked at the AAA protocol, for instance, it tells you the things that you should bear in mind in even choosing all of these platforms. So familiarize yourself with these protocols and have some sort of checklist at the back of your minds, and this should help. I don't know how many minutes I have. I've shared
then I'll give you a minute.
Mercy.
You know very well.
Ruthless.
You know very well. I'm ruthless. I'll give you a minute because you are guests from far, so that I bully the one near me. Guests from far, I can give you 1 minute. So you just conclude.
Okay.
So in 1 minute, let me just, look at have at the back of your mind these considerations. First and foremost, the local legislation, does it even allow for what you're thinking of doing by the use of virtual hearings or arbitrations? Also, the integrity of the process. Remember that at the end of the day, what you want to protect is the sanctity of your award. So what are those steps you need to take to protect the integrity of that process? And then, and for all of these, the protocols help you to, put in place some sort of system that will grant that integrity to the whole of the process. And then, you have an enforceable award at the end of the day. Thank you.
So much, Diane, and I think our team is on site, and we generally will want you to come in now properly. We need to really delve into perhaps our next conference during the training, half day or even the whole day, on these specific issues of cybersecurity, because as you've clearly highlighted, there are matters that we need to take very seriously. So I'll quickly then move to Cecil next to me, who is already minus 1 minute, which I've borrowed from the guests, because they are from far. Your house is behind here. So, so Cecil, moving away from cybersecurity, of course, we've seen that the ICC released the report on the leveraging of technology in arbitration for fair and effective international arbitration practice, which was lauded, of course, as one of the most advanced reports in that way. And of course, it highlighted how technology would be useful to this practice. And of course, increasingly parties, even in my arbitrations, parties nowadays, not like before when you had to convince them to serve you electronically, they use hyperlinks. So things have sort of moved in that way. But yourself, you act as basically as counsel in arbitration, internationally and domestic, and also as arbitrator. Now, let's just bring this home to domestically Africa. African arbitration seated here, either domestic or international, whatever the case.
Yes.
Do you really think we are there in terms of the kind of technology that you see exhibited when you've done arbitrations outside the continent or even outside this country? Do you really think even with this embrace we are there and technology, or should we just revert to where we were and live happily?
No, I mean, I think to be honest, where we were before, we are not going back. The judiciary has led the way. The virtual court system is now our mainstay. I see practitioners here that I usually haggle with in court every other day. So for me, I think it's a leap that we took. COVID, yes, was devastating in many respects. But it was a leap. It was almost like a 10-year leap that we achieved in a week, and I don't think we are going back. I read somewhere that there is a survey that I think Prof did in 2020, where they were assessing what are the key elements that parties usually consider when they are choosing their seats, and the three elements. One, of course, is the availability of expertise. Number two is arbitration-friendly jurisdictions, and surprise, surprise, number three is access to modern technology and facilities. So you can see, I mean, I think most users are really keen to see that a seat is particularly well stocked with capability in terms of the technological offering. Now, speaking for myself. Both as arbitrator from time to time and as counsel. I think starting from my sitting as arbitrator, I mean, it's almost default nowadays that sessions or meetings are held virtually. It's very rare that you would have parties opting for an in-person hearing. In my view, I think it's much cheaper, to the parties, both in terms of paying their counsel, but also paying the arbitrators, charge out rate. As they say, some of these arbitrators don't come cheap. I think in terms of the wider scope of sitting as counsel, especially in an international arbitration, I was privileged recently. I should speak carefully. I was privileged recently to sit in an LCI arbitration, and you know, we had on the other side, you know, a leading law firm, and we had a panel of 3 arbitrators, one sitting in Nairobi, and 2 others sitting in London. And I thought the sessions were carried out quite seamlessly. I think the challenge that we faced in terms of the technological capacity that we had is with service providers, because initially the arbitrators required, you know, a real-time transcription service, which we couldn't find here in Nairobi. We were only finding it in Dubai, in South Africa, and in the UK, which was astronomically expensive. We opted for other means. The other thing I think that I saw that worked quite seamlessly. For me, I think the direct answer to your question is that we are ready. You know, it is not an accident that you know, we have. They say that one of the greatest communities that we have on social media is called KOT. Is it? I'm not on Twitter myself, or is it NOT? Exactly, Kenyans on Twitter or Nigerians on Twitter. I don't know which is the greatest. So my point is that in terms of capacity and being ready, we are ready, but I still think that there are some teething problems. One of the frameworks I think that usually helps is the rules and guidelines that are supposed to guide these virtual hearings. For example, Diane mentioned it, the Africa Arbitration Academy, you know, has led the way with their protocol on virtual hearings. Of course, I also know that we recently amended our own Chartered Institute of Arbitrators rules to cater for, you know, incorporation of virtual hearings. So there's still opportunity and scope to better develop, you know, where we are. But I still think that we are there. We are able to compete with the best, you know, in the market, you know, globally. Yeah.
Thank you so much, Cecile. You kept it short. Clearly, I know now you are used to having your time capped. Short and straight to the point. Thank you. And you've heard there's a business opportunity for those who did not catch it. Real-time transcription services. Agpo people register those companies and make top dollar, and it will be a bottom-up real model. Now, the last round of questions will be quick fire, rapid, no time wasting. I'll quickly start with Diane. Diane, I think we've been in very many conferences, and I think specifically this being ICC Kenya, I must just jump in and ask you a general question around insolvency. I am aware that now you have the BRIPAN conference ongoing as we speak. It's happening in Nigeria. As you have now learned, I even know things in Nigeria. You have seen I'm real Nigerian, half Nigerian. Insolvency and arbitration. These are conversations that started coming to light during the pandemic, but from where I sit, actually, I've not seen exploration of that area in a matter that I'd say proper. However, the problem with this insolvency, it affects an arbitration proceeding, as it were, right from the point of initiation of the proceedings up to the point of enforcement. So the intervention of courts can be at any point, and that is one of the areas where you found courts having to intervene. I'm not going to name names or say anything, but I was also served with a court order for an arbitration that now I don't know, the company went under. Let me not give more details because it's a popular one. But those who were among the arbitrators appointed here in Kenya know that was a first, and it affected at least 600 of us. Nonetheless, Diane, tell us about your thoughts about insolvency in arbitration and the role of courts. And do you see this being now more prevalent as we move on, and of course knowing the effects from the pandemic? Thank you.
Thank you, Marcy. So let me speak on, let me talk to your question from 2 angles. First being, what would the general attitude of the courts be? You know, and then secondly, maybe some sort of panacea to the, you know, insolvency aspects, if you will, but I'll just very quickly ask the question, the attitudes of the courts. Take, for example, the Singaporean case of Singapore Limited and the bank, the VTB Bank. It's a 2020 case, right? And, that case had to do with a party who had approached court to wind up the company of its debtor, saying that the debtor could not, satisfy the debt. But the debtor had a dispute, was going to bring a dispute against the party who went to court, and on the basis that, look, there is an arbitration clause. Why don't we go to arbitration first, right? To talk about the indebtedness before you talk about winding up orders. So winding up has, the courts have jurisdiction for winding up. But curiously, the Singaporean courts, the Court of Appeal, said, look, regardless of the fact that we have jurisdiction over winding up, the root cause of this is a debt. It's a commercial transaction, and there is an arbitration clause, and the courts stayed action. So progressively, you begin to see that courts are, honoring arbitration agreements, if you will, and are limiting, their interventions to actual interventions rather than interference in the whole process. And then this brings me now to the whole gamut of insolvency and even going through the process of arbitration by parties, And lately, we find that, especially within the African continent, third-party funding is beginning to be top of mind. Professor Emilia talked about, the new bill, and I find that jurisdictions are beginning to put even provisions for third-party funding in legislation. So the Nigerian Fingers Crossed Act very soon has, as one of the new provisions under Section 50, a provision for third-party funding. What that does is that it gives, investors who are now investors in arbitration more comfort to know that, look, there is fertile ground for recovery of my investment in this arbitration. And it manages to, give room for this arbitration to actually take place. For practitioners, this should be welcome news, because it means that more arbitrations, more parties better equipped to actually go through the whole of this arbitrations and the disputes, alternative dispute resolution mechanisms. So let me just rest there.
Thank you so much, Diane. I'll ask Professor Emilia to kindly add her views on this issue of insolvency and arbitration. We are winding up soon, so do not worry. Thank you, Prof.
Thank you very much, Mercy. My view is that when it's a question of statutory winding up of a company, that does need to go before the courts. And I appreciate that Diane has made that distinction. And I think that's the difficulty with the Singapore decision that she had cited. So there is the need to support arbitration. But what we heard in ICA, and which is, in my view, the correct position, is that arbitration is one of the mechanisms in a spectrum of dispute resolution mechanisms that we have out there. There is a role for the courts. And don't forget that maybe the subject matter of the arbitration is why the claimant is facing bankruptcy and insolvency in the first instance. So, of course, when it is a commercial dispute or a private, let me put it that way, a private dispute that does not implicate the interests or the rights of third-party or the creditors of the company, then clearly that's something that would be arbitrable. But where the company has gotten to a point wherein the creditors may need to wind it up, then that is something that, in my opinion, the courts need to be dealing with. And on the continent, a number of companies, relevant laws that deal with insolvency would give the courts jurisdiction to deal with that. Just a quick point on third-party funding, which is something that Professor Muiga mentioned this morning about the fact that he's a little bit uncomfortable because of portfolio investors and the fact that African states may also be opening themselves up to investment arbitrations arising from those sorts of participation in the system. I think we need to be a little bit careful. I agree that there is a question of access to justice, and that's important, and where parties cannot afford to bring cases that third-party funding would help. But at the same time, we do not want to become a fertile ground for frivolous applications being funded by third-party funders.
Thank you so much, Prof. Now, the last question, really, I know if I don't let Diane answer, she will do something dangerous to me in Ghana. But I'll start first of all with Cecil, Dr. Emilia. Depending on how the audience feels, I'll throw 30 seconds your way, Diane. Even as we speak about all this technology, all these emerging areas, and all these new beautiful things, AI, and seeing that things are moving ahead, and we're looking into the future, there's one constant, and that constant is manpower, humans. Humans are still very much at the middle of this arbitration and generally ADR space. With that, younger and younger people are actually getting to this field. You know, when I used to be called young this, young arbitrator of the year, young arbitrator of the year, I used to win those things. Nowadays, I see the young arbitrator of the year, it's my student in Strathmore. That's the young arbitrator of the year. I look at the young mediator of the year, it's a person who's 19. You even wonder, when did they do these courses? So Alim, I know we are exiting, but in our days, we were the young ones. Increasingly more people are sitting as arbitrator as young as in their 20s. James, I'm talking to you. People who've gone for international matters, even beyond, basically in their early 20s, early 30s, things that could not have happened when most people were getting into this. What are the top 3 things, Cecily would say? Because technology is good, but manpower, as we say in Kenya, is more important. So, what would you say are your top 3 things for anyone either looking into this field and wanting to get in, or someone in it and thinking, I'm young or I'm old, or they're not too sure where they are placed? I'll give you a minute and a half. I'll give you Dr. Emilia another minute and a half, and Diane, I'll give you 30 seconds so that we can close this panel.
To the extent that you fielded that question to me, I take it as a compliment that
Yes.
I'm also young, right?
You are
Thank you so much. Thank you. So I think start with the basics, in terms of this field. Number one, identify with the community. Wear the uniform. What we are doing here is part of it, ensuring that the most important event of these sessions is the networking. Hopefully that is presumably after this. I think for me that is most important in terms of growing my repute, I think, in this community as a young person. I think we should not shirk the responsibility of acquiring the credits. People usually say that having these titles maybe doesn't help, but I think it's ultra important that we acquire the credits. Of last count, I think the chartered arbitrators were less than 50, I think, in the nation. There is still space for all of us. I still couple myself in that. And also, I think it takes a lot of humility. Humility to offer yourself to be mentored. Humility to offer yourself, even volunteer as a tribunal secretary. There's scope for that in international arbitrations, where you can learn, by actually doing. There are emerging areas, that all of us can participate, and Dr. had talked about it, I think, in his presentation together with this panel, climate change and sustainability related disputes, fintech, crypto kind of disputes or complicated license or patent disputes. I think there's scope for that. And the space is ours, to take that and run with it, because I think opportunity abounds for all of us. My dad usually says that opportunity is like the sea. I don't have to kill your opportunity in order to gain mine, but it is available for all of us. Yeah, that's all I can say.
So much, Cecil. And Professor Emilia, before I allow you to speak, let me just say my 10 seconds. When I was doing my second master's, which is a master's in international arbitration, I must say second, I'm a Luo, you must know I have 2 master's degrees. Professor Emilia is the one person, when I graduate, I'll tell people the real truth, but I gave her sleepless nights when I could not understand exam questions, assignment questions. I'm like, Prof, what's the meaning of this? Then that's when I realized investment arbitration is not so hard. At my big age, I was in tears. But of course, it's the people who went before us, like Professor Emilia, who've, of course, given us the opportunity to even sit here. Thank you. So, Prof, your thoughts?
Thank you very much, Mercy. This morning, the panel this morning hammered on ethics. And we cannot overemphasize that. And it's important that whoever is mentoring you, whoever you're learning from, that personal integrity is your badge, that you wear it. It becomes who you are. And as usual, I would say, if you're looking for money, sitting as arbitrator is not for you. Go and do counsel work. They make more money than arbitrators. Even though I might now begin to add a comma to that when it comes to the African continent, because sorts of monies I hear that the arbitrators charge is ridiculous. But at the same time, we do also need to, just as Mercy has said, as Cecil has said, just be relevant. The only caveat is be comfortable in what you do. It's so important. So yes, we talk about AI, crypto. In ICA, somebody was talking about disputes that would arise from cloud and from water. Yes, but if none of those sit well with you, do the ones that sit well with you. If it is Kenyan law, knowing what Kenyan law on contract or whatever is, if that is where you're comfortable and confident, then continue to improve your knowledge on that, in that area. There will be work that would come on that. It is really important. Don't follow the crowd. Find out what is it that I am comfortable, because that's when you will be imaginative and that's when you will be convincing. But if you're just doing, they say we should go and learn AI, and you go and learn and struggle and struggle and struggle. If that's not who you are, it can frustrate you. So think of what sits well with you. Mercy.
Thank you, Prof. Now I'll have to unsubscribe from my AI classes because I've been really suffering. Anyway, thank you for that. Diane, you'll have 30 seconds to give us your 1 or 2 in 30 seconds things that you'd say looking into the future that you'd tell a younger you or even you now that you've learned.
Okay, thank you, Mercy. And, let me just speak to, or just build on what young Cecil, you see emphasis on the young, right? Young Cecil has mentioned, and then Professor Emilia, right? So in addition, competence, you honestly, in this industry, in this market, it is impossible for you to make any headway that is meaningful without the competence. The community is so small. They will find out. So it's one thing for you to be everywhere. It's another thing for everybody to know you. But your first opportunity, the second opportunity you're given, and you're not, you don't exude that competence. Trust me, the community will, word will spread. So like my big sis has said, my big sis being Emilia, not Mercy, by the way, has said, whatever it is that you're comfortable in. And, the thing about ADR, arbitration, is that there's work in so many fields. So if you're not an arbitrator, you're not counsel, you can actually be an expert witness. So if it's Kenyan law you're comfortable in, you don't need to be an arbitrator. Just know the law, and everybody is calling you as, an expert witness. Why not? You're still within the arbitration community, So those are my 2 pence within 30 seconds, by the way.
Thank you so much,
Mercy.
Diane. And that brings this panel to a close. I'd like us to give a round of applause to our panelists who had to wait since we were running late. Thank you so much, Cecil on my left. Thank you so much, Diane, all the way from Lagos, and Dr. Emilia in London. And I hope I'll see you soon. You'll text me what you want me to bring you from Kenya. And thank you, of course, to the audience for their patience. I know we've overstretched this panel, but I hope you got something to learn, and then something that was of value to you. Thank you so much. Back to you, Wanjiku.
Thank you, Mercy. Thank you, Diane and Emilia and Cecil as well. So, wow, it's been a long day, but thank you very much for your patience. I know some of you have been here since 7, so thank you very, very much for staying to the end. So I'll just call upon Gordon Ogola to give the closing remarks.
Good evening, ladies and gentlemen. Perhaps before I say anything, I would want you to give a round of applause to yourself. There's a gentleman seated behind there. He's called Gordon. My name is The Gordon. So you know the difference. That is Gordon. I am The Gordon. All protocols observed. Ladies and gentlemen, I am not an arbitrator, even though I've interacted with it, sometimes either as a student or as a counsel. But I've been given this task of making the closing remarks in a conference attended by eminent arbitrators. I was wondering what went into the minds of the organizers, why they gave it to me. And I thought probably I was given this role because at the end of the day, the participants would have gone through almost 12 harrowing hours of listening to technical stuff. So they thought probably we need somebody not technical enough. We need somebody who maybe didn't understand much. We need somebody who will come here and will not take another 45 minutes going through the technical stuffs and making observations. I think that's why I am here. I looked at the program and I saw I was given 15 minutes to make my closing remarks. I was wondering whether it's a closing remarks or is a vote of thanks or is it some mongrel between there. I decided to call it concluding remarks. I'm going to request out of your very busy time and hectic evening just to give me 45 minutes to go through my concluding remarks. I am very honored and delighted to deliver these concluding remarks on this auspicious occasion, on this last day of the second annual ICC Kenya International Conference, whose theme was the emerging trends in arbitration and ADR in Africa. First of all, I would like to thank Diamana Diawara, the Director of Arbitration and ADR Africa, for the support her office gave us to ensure that this conference took place. We do not take it for granted that you did create time out of your very hectic schedule to come here in person. A big round of applause to Diawara. Our gratitude also goes to the ICC Kenya office and KEPSA for giving us the platform, the necessary support, and the motivation to ensure that this conference is a success. A big round of applause to them too. A big thanks, though, goes to the ICC Kenya Arbitration and ADR Commission, headed by our chairperson, Alim Visram, and the secretariat led by the indefatigable Lloyd Mwaniki, for the enthusiastic and dedicated work. I recognize that indeed they put their hearts and souls to make sure that this thing happened. We also appreciate the moderators, the panelists, and speakers led by our senior counsel, Githu Migai, Kamau Karori, Njeri Kariuki, and my distant mentor, Kariuki Muigwa. I was telling that when I entered the ADR world, the first articles I interacted with were his, and when I did my dissertation in mediation, enforceability of contracts, of awards, what I did was basically borrow mostly from the works that he's done. We are also thankful to our sponsors, the G&A advocates, Mohamed Muigai, DLA Piper, J. Miles, and our partners, SIAB Kenya, NCIA, and Arbitral Women. However, most importantly, I would like to thank all the participants. Without your input, ideas, and discussion, this workshop would not have been the success it has. We are indeed extremely pleased that this conference was well attended by various stakeholders, ranging from students, policymakers, industry practitioners, and experts, among others. Give yourselves a round of applause, participants. Apart from the rich panels that were filled with insightful content, the participants also benefited from the views and knowledge from amongst themselves. We hope that you have enjoyed networking opportunities throughout the conference and will take advantage of the technical expertise of our panelists, commissioners, and the staff, and what the staff can offer. We are aware, though, that our organization, by the way, where we come from, I remember Karoki saying yesterday that where they come from, when you have an L following an L or an R, things become very difficult. Where we come from, when you have an S and S following whatever, it's very difficult. So there are certain words that I'm skipping from this for that reason. Through this conference, we hope that most of you will be converted to the gospel of ICC arbitration and ADR services. We know one swallow does not make a spring, and we need numerous followers and a concerted effort to bring about the critical mass of change in this dynamic field. This definitely requires further hard work, as well as intellectual, financial, and human resources to fill these ambitions and intentions, and we will need all your support. To that extent, we invite you to partner with us, collaborate with us, and become part of ICC Kenya. We have 3 membership categories, that is individual, corporate, and business membership associations and categories. For that reason, if you are very interested, you can see our Mr. Lloyd for purpose of registration. Ladies and gentlemen, for reasons highly explained, I will say no more, and I will not touch on any technical aspect of what we have consumed today. In the very near future, we are going to have an inaugural mediation moot for African universities that will be conducted by the ICC Kenya, and we believe you will all partner with us to make it a success. Last but not least, it would be an abomination to end this conference or these concluding remarks without giving a big round of applause to the Gordon. Thank you. And that marks the end of this conference. Thank you very much, ladies and gentlemen.